Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Thank you. You may be seated. We have 4 arguments today, and we're going to plan to take a brief break after the second argument. So we're ready to hear argument in our first case. Whenever you're ready, counsel.
Good morning, and may it please the court. Donna Kagan McGinley for petitioner appellant Jason Taiwan Bell. This case is the quintessential case of someone for whom the remedy by motion is inadequate or ineffective to test the legality.
One thing I'm going to ask you to do is speak up a little bit.
Sorry, yes. Is this better?
Yeah.
This case is the quintessential case of someone for whom the remedy by motion is inadequate or ineffective to test the legality of his detention, is required for resort to Section 2241 under the Saving Clause. First, Mr. Bell meets the second and third prongs of Wheeler. Second, no one can get the statute held unconstitutional in direct review by the Supreme Court, and no one can get through under Section 2255. Third, Jones v. Hendricks left the door open to claims rooted in the history and tradition of habeas, and Mr. Bell's claim is analogous to one of those claims. I'm happy
What
to...
about our Fourth Circuit precedent now, Slusser and Farkas? That didn't leave any door open, did it?
So our position is that those cases have been rendered untenable by the holding, or their reasoning or holding, or both, have been rendered untenable by Jones v. Hendricks, and therefore this panel is not bound by them anymore.
How are they untenable by Jones v. Hendricks? They almost seem in line with it to me.
Jones v. Hendricks says that claims based on intervening statutory interpretation decisions cannot get through. Slusser and Farkas say that constitutional claims can't get through. If, after Jones v. Hendricks, both categories of claims can't get through, then nothing can get through the Saving Clause. At the very least...
Okay, so it's untenable because there is just no other recourse for appellant. Is that your...
And others. So essentially, two extremely...
But you're not saying that nobody can get through the Savings Clause, right? I mean, the court in Jones gave 2 categories of people, maybe only 2 categories of people, that do qualify under the Savings Clause.
Sure, but the court in Jones...
Not convicted by a court of competent jurisdiction, for example, right? That person would get through under the Savings Clause, right?
Sure, but Jones also didn't close the door on anything else that wasn't specifically enumerated in the Jones v. Hendricks opinion. It certainly didn't purport to sketch out the outer bounds of the Saving Clause. So at the very least, I think 2 cases that say that categorically constitutional claims, does not matter of what kind or nature, cannot get through, should be rethought after Jones v. Hendricks threw out an...
Jones v. Hendricks is pretty, at least the way I read it, is pretty limiting. It says 2255H specifies the 2 limited conditions in which Congress has permitted federal prisoners to bring a second or successive collateral attack. The inability of a prisoner with a statutory claim to satisfy those conditions does not mean that he can bring his claim in a habeas petition under the Savings Clause. And here's the key point. It means that he cannot bring it at all. Congress has chosen finality over error correction in this case.
In this case, which is a statutory interpretation case.
Right, but Jones, you're right, Jones was a statutory interpretation case, but Jones, in its analysis, relied on cases that involved alleged constitutional violations.
It didn't, I agree with Your Honor that Jones, begins with a broader analysis. I think as the opinion continues, it homes in more closely on statutory claims. I think at the end of the
So what Judge
section.
Thacker just read, just to make sure I understand your argument, what Judge Thacker just read, where she says 2255H specifies the two limited conditions that are permitted, one of those is for constitutional claims,
Right.
right? And it provides a set of specific circumstances in which such a constitutional claim could be specified under H.
Right, but I will point, Your Honor, to the very last paragraph of Jones v. Hendricks, in which Justice Thomas
Well, before
describes...
you move off of the language that Judge Thacker quoted, what I'm having trouble understanding, you're saying that the constitutional claims aren't encompassed in that sentence, but that sentence seems like, in fact, more directly addressing constitutional claims than statutory claims? It's anything under H?
If I'm not, first of all, that's not the holding of the case, and you're not bound by the holding of the case. And second,
Wait, why is that not the holding of the case? I
because
mean,
the
it's
case...
like the ultimate end of the interpretation is the straightforward one, and it provides the interpretation.
If
And I'm not going to read it again, but
If I'm not mistaken, that very paragraph then ends in Justice Thomas saying, Congress certainly did not think to provide an avenue for non-constitutional claims.
at the end of that paragraph says, Congress has chosen finality over error correction.
In his case, right. So maybe
Based on
it's-
an interpretation of a statute, but the interpretation of the statute is, I'm just having a hard time understanding how the interpretation of statute, which is what the holding is, that leads to that conclusion is different for constitutional claims, when constitutional claims are specified in H, right?
I don't think that we can read Jones to preclude constitutional claims categorically without running up into the suspension clause.
Oh, not categorically, right? Very much not categorically, because 2255H very specifically identifies which constitutional claims can be brought.
But 2255H does not provide for all of the kinds of claims that would need to be available for suspension clause concerns to not be
Okay,
triggered.
so I understand that argument, right? But that's a transition. That's saying, yeah, totally lose under Jones, but that shouldn't happen because of suspension clause. I think that argument doesn't work under Jones either, but that's a different section of Jones, right?
We are not conceding that we're losing under Jones.
I know, but your
Our
response
view-
to my question is, well, let me talk about a different argument, which is totally fine. I'm happy for you to talk about a different argument, but it doesn't answer the question of how I read this language from Jones to not encompass the very thing that it says is encompassed.
My response was an attempt at saying that Jones ought to be read with those concerns in mind, and given those concerns, we cannot read Jones to say that only this very narrow category of constitutional claims can get through, given that the saving clause exists and the suspension clause exists. So I don't think that we can take from Jones a much broader holding than it.
Are there any cases after Jones that support, any circuit court cases after Jones that support your position
In this circuit,
in any circuit?
I don't think that there are
I mean, I
any
know there aren't
cases.
in this circuit.
No, I don't think that there are any cases that have dealt with this particular
One way or the
situation.
other.
Right.
Okay.
And if you go to so if I can just turn back to the very last paragraph of Jones v. Hendricks, in which Justice Thomas invokes the history and tradition and essentially,
When you say the very last paragraph,
I believe, I don't have the case right in front of me, I believe it is the very last paragraph, in which he talks about constitutional norms and historical norms.
The last paragraph of the whole case, or?
Yes.
Okay.
I can attempt to give you a cite.
Well, we have the case. Go ahead.
In that paragraph, Justice Thomas leaves the door open, at the very least, to claims that are rooted in history and tradition. And Mr. Bell's claim is one of those claims. His claim is a void for vagueness claims, and those have been cognizable even before we had a constitution under the Magna Carta. We liken his claim to one that argues that the court under which he was sentenced was without jurisdiction. If you go back to a higher up in Jones v. Hendricks, not the last paragraph, Justice Thomas articulates not a rule, but an explanation in which he says that historically habeas was not available to claims that concerning convictions or sentences that were handed down by courts of competent jurisdiction. There is historical debate over what that means, but jurisdiction at the time did not mean what it means today. And a court that sentences someone under a statute that criminalizes no discernible conduct effectively sentences that person without jurisdiction, without power to do so. And so our position is that if you are going to proceed under
That's the Jones dissent, right? I mean, that's, I totally get that argument, and like, it's not, I mean, it's a reasonable argument, right? It's just the one that Justice Thomas rejects and that the dissent makes in Jones, right?
they
Why is your
engage in a,
argument different from the dissent, right? Because obviously the dissent in Jones, like, doesn't help you here, because we don't get to make that judgment. You might be totally right. Might not be right, but you might be totally right. But making the argument that we should adopt the dissent's version of the history is a tough argument. So how is your argument different from the dissent's argument?
first of all, I think that they engage in a historical debate, but I want to emphasize
who's they in that sense?
Sorry, Justice Jackson and Justice Thomas. There's a historical back and forth, but I want to emphasize that the kind of claims at issue here, even just based on a plain reading of the words of 2255E, inadequate or ineffective, compel the result that we are advocating for, because this is a situation in which not a single person can get this substantive law generated by the Supreme Court. Not a single person can get through 2255, and yet we have a decision on the books that says that a statute that is phrased the exact same way and works the exact same way.
Like Jones, the whole point of Jones is that, like, you can't bring these statutory claims under 2255? Like, they don't exist?
No,
right?
but this
So,
is
like,
a void for vagueness claim. This is a constitutional claim.
All right, it's Thursday, right? But why does that matter, right? So, like, I understand that, like, that was a Tuesday and this is a Thursday. But, like, in Jones, the whole point of Jones, I thought the most compelling argument in Jones, and Justice Jackson made it, is that if not here, then never, then no way, right? This person can't bring the claim.
I see that my time is up. Should I?
Yeah, please
may
respond to Judge Richardson, and then you can wrap up.
I don't think it's a Tuesday or Thursday, because the type of statutory claims are one animal. The constitutional claims of void for vagueness claims are a special breed of claims that have been cognizable even before we had a constitution. And I think that you can say that, therefore, those claims emanate from historical and constitutional norms that would permit them to go through under the saving clause. And at the very least, this is not something that Jones v. Hendricks foreclosed just by opening that door to those kinds of claims.
All right, thank you. You
Thank
have
you.
some time in rebuttal. We'll hear from Mr. Crane.
Good morning, Your Honors. Paul Crane on behalf of the warden, J.C. Streeval. Mr. Bell is not entitled to relief in this court for two independent reasons. First, and including what was the discussion that already happened with my friend on the other side, is that the district court here correctly found there was no subject matter jurisdiction under Section 2241, a conclusion that is just strengthened even more by the court's decision in Jones v. Hendricks. Judge Thacker, to answer your question, there is no federal court, this jurisdiction or otherwise, that has granted relief post-Jones v. Hendricks on a 2241 petition to a challenge of a conviction
Well,
or
are
a
there any
sentence.
that have denied relief?
In circuit
So are
courts,
there-
unpublished opinions, and then
Right,
district
so-
courts saying no.
So nothing one way or the other?
Not in a
Nothing-
published Court of Appeals opinion, as far
Right,
as I'm
which is what
aware.
counts. Okay.
And under Jones v. Hendricks, for reasons set forth in our briefing, there's just no basis for Section 2241 relief here.
Well, what is the historical basis for reading constitutional claims out of Section 2241, going back to where Ms. McGinley ended her argument?
A few answers to that, Your Honor. So, as Judge Richardson noted, not all constitutional claims are read out. Just there's a certain limited subset based on Section 2255H2. This court in In re Vial, sitting en banc in 1997, held that the limitations in 2255H do not violate the suspension clause. So under that holding, this panel need go no further than that. The court in Jones v. Hendricks also strongly indicated that the suspension clause only protects the writ as it existed at 1789. And I don't think there's any historical basis for this particular type of challenge to a mandatory guideline provision, as opposed to, is there a court that lacked competent jurisdiction that entered the conviction?
And so if appellant's sentence is in fact unconstitutional, he has no recourse at all under appellee's view of the case law as it stands.
That's right. If there was a constitutional error in Mr. Bell's sentence, there is no relief. In the words of Jones v. Hendricks, Congress has chosen finality over error correction, and that is the case here as well. And my friend on the other side acknowledges that they can't satisfy 2255H2, which is why they sought to utilize 2241, understandably. And Jones v. Hendricks closed the door to statutory claims. It did not open any constitutional doors. And as Your Honor noted, this court's decisions in Susser and Farkas also make that quite clear. The second independent basis that this court could deny relief, in which case it would vacate the decision below and with directions to dismiss under Munsingware, is that this appeal is now moot, as set forth in our
Go ahead.
as set forth in our brief. There's no basis for a redressable injury at this point in time.
So I take your point as an initial matter, but help me understand why this doesn't sort of play. He's serving a 5-year term of supervised release.
It's now been 3 years, Your Honor, because of parallel 2255 litigation.
Okay, so it's a 3-year term. The length of it doesn't, I think, maybe matter. Maybe it does. You'll tell me if it does.
No.
So he's serving supervised release now?
Yes, Your Honor.
If a court, I mean, there are a lot of ifs here, right? But we have to assume the merits, right? So if he was granted habeas relief, and so the court said under 2241 that they had to vacate his sentence, and then whether it did it or whether it sent it back to the sentencing court to do it, it had a resentencing that would take place because he's still under a sentence of supervised release. Couldn't a district court doing that resentencing say, listen, you served more time than you needed to, and so I'm going to reduce your term of supervised release?
Well, under the Supreme Court decision of Johnson v. United States, I don't think that the sentencing court could say exactly that, of I'm going to give you a version of sort of compensation for over-served prison time. And therefore,
It's not compensation, right? It's like, I now am resentencing you in the light of the circumstances that exist. I determine that you need less supervised release, or maybe just the conditions are different of supervised release.
I think that is correct, Your Honor. I think here, because all that's left is supervised release, Mr. Bell could go file a motion for either termination after having served 1 year or a motion to modify the terms of supervised release. But in the
We often
sentencing
say
court,
that the fact that you could get relief in another proceeding doesn't moot the proceeding that you're in, right? I mean, you might be able to do lots of different things, right? But that doesn't make this proceeding moot. I mean, there's a possibility, the point of mootness, right, is there some possibility that he could get some benefit, right, a lesser length in time or just lesser restrictions on a resentencing, were the court in this hypothetical world where like he got relief under 2241.
And I understand that position, Your Honor. I think our position is that is too speculative because it is the sentencing court that would ultimately be addressing supervised release. And so that sequence of dominoes is just a few too many, even if it might be
I mean,
helpful.
don't we think about like Carafas, right? The sort of collateral consequences, right? If anything, those are like more speculative than this. I mean, this seems like if we assume the merits of the litigation, which we have to for mootness, like the idea that a district court would reimpose the exact same 3 months doesn't seem at all far-fetched to me. Well, and compared to like Carafas's, or however I'm supposed to say it, you know, the collateral consequences there are like beyond speculative in most instances.
Yeah, and I understand that, Your Honor. I think the Supreme Court in that line of cases has presumed that there will be collateral consequences somewhat to avoid that speculation problem. Now, the Supreme Court in later cases has certainly cut back and said if it's only a challenge to the sentence, then we're not going to have that same presumption as we would for a challenge to a conviction, which is...
I get that. That's why we're talking about supervised release.
Right.
I totally get that we don't get to assume those in the sentencing case, but we still have this problem that because the supervised release could be reduced, he has, for mootness purposes, a sufficient interest in the litigation.
I'm not sure, I agree with all of that up to, it's not, I don't think it's clear that the habeas court could be doing a reduction in supervised release as opposed to the sentencing
But that's
court.
the ultimate relief versus the like intermediate relief, right? The habeas court could certainly, a 2241 court could vacate his sentence.
The entire sentence.
The entire sentence, right? And in that instance, it then would go somewhere. We can debate about whether it's the 2241 court or whether it's the original sentencing court. I totally get that debate. But it's just like a choice. It's one of those two. It's not none.
I think it would ultimately be the sentencing, but yes, I take your point, Your Honor.
Right? And then the sentencing court could then make a reasonable decision. I'm not saying it would do it, but it's certainly a reasonable decision to say, I'm going to be less restrictive on the terms of your supervised release, given the circumstances that we currently have.
Yeah, and that's certainly theoretically possible. I think we say that's still a little too speculative and instead is more naturally housed in a motion under 3583 to modify or in a few months from now seek to terminate for exactly all those same reasons. But even if, assuming the court disagrees with us on that, the first basis kind of forecloses relief regardless. So whether it's...
We got to decide mootness first, right? So
don't want to keep sticking my head in the lion's mouth. I disagree with that, Your Honor. I think you could decide either one because they're both threshold grounds. Exactly. So I think the court has the discretion. I understand that the order of operations might feel more natural to do mootness,
that's fair.
but I think this court could actually do either, and up to your discretion whether you want to address both or one or the other. Unless the court has any additional questions, we'd ask either an affirmance for the district court or vacater under Munsinger.
All right, thank you.
Thank you, Your Honors.
Ms. McGinley?
Thank you. Just a few points. So first, with respect to Jones v. Hendricks, this court is bound by holdings, not language, and certainly not by the historical narrative in Jones, the entirety of it. All we can get for certain from Jones v. Hendricks is that statutory claims cannot get through, and that we ought to continue being careful in our analysis so that the exceptions don't swallow the rules and we don't make an end run around EDPA's limitations. Going back to our earlier discussion, I don't think that the answer can be 2255H provides two circumstances under which someone can get through with a second or successive motion, and that's it, and that's the answer. The question is that enough? That's the question that we're asking under the saving clause. And what does the suspension clause say about that? And that's what we're trying to answer here. And as a result, I don't think that the right reading of Jones v. Hendricks is categorically any constitutional claims that does not meet Section 2255H2 is out the window, just based on Jones v. Hendricks. If there aren't,
Do you want to respond to the mootness argument?
sure. I just want to emphasize that, like Judge Richardson was saying, all we need to know is that there is a non-trivial chance that he will get relief, and vacature of the sentence is enough. The exact remedial mechanism that will follow that is a question that can be decided later. I also want
Do you have a view on whether the 2241 court or the sentencing court would be required to do any modification or resentencing? You don't have to have a view on that. This is like totally arcane,
No, we do.
habeas stuff, but
We do. We don't see a reason why the 2241 court can't engage in plenary resentencing, that as part of that will shorten or lengthen the period of supervised release. We don't see anywhere in 2241 or 2255 or 3605 anything that says that. If that's not the case, this court has the
what
power.
authority under 2241 would give it the authority?
No.
Maybe the flip is what, but
Sorry,
the courts have the power that are given to them by their statutory grants, and 2241 gives it the authority to review or set aside the judgment?
On the affirmative, it's that 2255 was enacted to mirror exactly, remedially, what 2241 provided. So there's no reason why a 2241 court can't do everything that a 2255 court can do under 2255B. And what I meant earlier is that there's nothing in those statutes or any of the statutes that the government cited that says explicitly a 2241 court cannot engage in plenary resentencing that will impact the term of supervised release. And I want to emphasize that as far as speculative is concerned, Mr. Bell, if sentenced today without his 924C conviction and without his career offender enhancement, his guidelines range would be 84 to 105 months. That's 7 to 8.5 years. He served 21 and a half years. I think that we can safely say that any court, whether it's 2241 court or 2255 court, would weigh that significantly in resentencing and take that into consideration when making a decision on his current term of supervised release.
All right, thank you, Ms.
Thank you.
McKinley. We'll come down and greet counsel and proceed to our next case.
Panel. It's my pleasure to be here. Thank you for granting oral argument in this case, Johnson versus Eldor. This is a matter coming from the Western District of Virginia. This is an FLSA retaliation matter. This is a matter that was dismissed on summary judgment by the district court, and the district court highlighted the manager's rule in doing so. The manager's rule is an issue that we're going to be discussing today in the panel, and it is a rule that has come, there's a movement of, I should say, disfavor across the country related to the manager's rule. The Ninth Circuit dismissed it entirely. The Masters took it away from Title VII in 2015.
Can I back up a little bit?
Yes,
Did
ma'am.
appellant ever
Sorry.
specifically invoke the FLSA to appellee?
Did the appellant satisfied the report of a complaint regarding FLSA activities under Kasten? The appellant never used the letters FLSA
Okay, so
in
that
raising
would be a
any
no.
issue.
So what's your best argument as to how appellant put the appellee on notice
Sure,
that there
thank
was
you,
an
Your Honor.
FLSA issue?
There is no requirement that the appellant actually utter those letters or
Okay,
say.
but any didn't, so what is it? What's your best argument?
Sure. November of 2018, 1 month prior to the termination, he reported to the plant manager, Fabio Piscone, and Human Resources that, as his testimony said, I brought up to Fabio Piscone that I'd found the legality in Virginia being you can't work a non-engineer over 40 hours without some compensation. That is what was characterized in that meeting. There was then an additional protected
How many
activity.
non-engineers were on his team?
I'm sorry, I don't have that information right this second, Your Honor. It was
Right,
probably
because-
about, I think it was less than 10.
But because everything else we hear is him talking about like his engineers work.
Correct,
right?
correct. He is not talking about his own overtime. That is clear. He's not talking about a compensation owed to him.
Or
He's
Wilkinson or the other folks that we see on his team that he does talk about.
He's talking about employees, he's not a lawyer, but he's talking about employees that it's under his understanding under Virginia law, as he said in his email to Giovanni Scafidi, that they were owed additional compensation for working more than 40 hours. Virginia law follows and tracks the FLSA. It mentions it by statute. It says in the statute for the minimum wage, the Overtime Act. So from the perspective of the Supreme Court and other precedent, the plaintiff did engage in protected activities without consideration of the manager's rule. It's the appellant's position that the appellant absolutely engaged in protected activities under this law. Now, it's the appellant's position that the manager's rule should be disregarded.
The protected activity that you suggest is that it gave fair notice
Yes.
that he was filing a complaint about the failure to comply with the FLSA.
Yes, Your Honor. Under Kasten,
That's the fair notice piece.
Yes, filing a complaint can be a verbal communication from someone to
Yeah, but the
management.
key part of that's fair notice, right?
Right, correct.
This isn't about trying to get, bonuses or time off or other things, that it has to be, you need to be paying them time and a half.
Correct. Well, he never said time and a half, but he did say
I
additional compensation for more than 40 hours of work for these workers. And that's the overtime law. That mirrors, the state law, that mirrors the federal law. And
So can you respond to that idea that, with due respect, like, none of the other things that he says suggest that, right? They're all ideas that he's given to kick in at 50
Sure.
hours or 60 hours, or when they come in on holidays, they get, extra time off or the like. I mean, all of those things suggest that his complaint is that my exempt employees need to get like a little more juice, right? So everything else he says is about my exempt employees getting a little more juice, right? I don't want to oversimplify, but that's the basic premise, right?
Respectfully, Your Honor, and I appreciate the way you're summarizing it, I would argue that it wouldn't be put in that description.
Hypothetically accept that everything else he says is, I want my exempt employees to get more juice. how do I read this one sentence, which
Right.
I take as your argument, this is my best sentence.
Right.
How do I read that out of the rest of this context?
Right.
When I'm looking at a cast and fair notice question.
Right. Well, thank you, Your Honor. The other information contained within his communications doesn't seemingly overcrowd, obfuscate, or block, or otherwise omit what he has already said. I'm unfamiliar
When
with
we're
a
looking
case.
at notice, it does sort of dilute or confuse the issue. It doesn't provide, and especially fair notice, it doesn't
Correct.
provide fair notice to the employer when he's proposing solutions that aren't time and a half pay, but are bonuses or other incentives that kick in at 50 to 60 hours. How is that fair notice of an whatever it is?
FLSA.
Yeah.
Yes. Thank you, Your Honor.
Violation.
Of course. Good point. I'd say that in response to that, in order to provide, again, the appellant is not an attorney, and the appellant's understanding of what could solve the problem, what solutions might be available, what remedies are not truly germane to a protected activity when it's already been made. When he's offering solutions, when he's talking about things that could remedy the problem, that doesn't eliminate the fact that he highlighted the problem itself. The problem itself being these people are not being paid 40 hours. May I talk a little bit about the manager's rule?
Let me ask you a quick question about that real quick, though. Doesn't, and I'm going to mispronounce the last name, Scafidi, doesn't he testify in his deposition, I think it's J81010, that that his interpretation is that Johnson is emailing him regarding workers needing to be paid overtime?
Yes.
All right, so he acknowledges that
Yes.
so if notice is an issue, he's
got
acknowledged that he's been placed on notice that workers maybe should be paid overtime. I think that's J810.
Thank you, Your Honor. I'd like to thank you, Your Honor, for pointing that out. Regarding the manager's rule,
So, wait, can I just understand that? We understand Scafidi. So there are two interpretations of overtime there, right? One is the one that Mr. Johnson primarily talks about, which is like, my guys need some juice because they're working too hard, right? And the other is the FLSA requires time and a half for any non-exempt employee that works over 40 hours, right? It seems like to me when I read Scafidi, he's talking about the piece that Johnson is talking about, which is pay my guys more because they're working, like, I understand overtime's necessary, but like you need to give them extra pay or extra time off or something once they get to 50 or 60 hours.
I'd argue that back and forth highlights the fact that he did mention that overtime was an issue, was at issue. The fact that is in communication, the fact that he is saying that. And don't forget, these are individuals.
But exempt people and non-exempt people both can work overtime, right? I mean,
They can both
my
work more than
clerks
40
are
hours.
exempt,
Right.
right? So they don't get paid for overtime.
Correct.
Right? But there's no doubt when they're in the office on Saturday, we would all refer to that as overtime, right? They're working overtime.
Well, respectfully, the employment
You're an
lawyer
employer
would
lawyer,
not say that.
Everybody else in the real world, right, would refer to them working overtime.
Oh, perhaps in the common parlance, yes, Your Honor. But, Your Honor, again, how many peels of this onion on the protected activity are we going to go for here? Because it's when an individual who is not a lawyer repeatedly highlights these issues, yes, there's other information that he characterizes along with it, but it doesn't eliminate the thrust of what he's highlighting. Now, the manager's rule
For
says,
sure, there may be issues. It's just the question of whether those issues rise to the level of an FLSA complaint. Speaking of that, I want to ask you about something in your brief. You say on page 3 of your brief that appellant's complaints ultimately led to an FLSA collective action
Yes.
against FLE, and there's notably no JA site for that.
It was a separate matter.
And appellee says that there's nothing in the record that indicates that's the case.
That did occur, but it is not, I apologize for it not being in the record. There was a separate FLSA collective action against Eldor that I represented engineers on that was going contemporaneous to this case. That case was resolved and didn't result in a
So it's not this case?
It is not this case, but Mr. Johnson provided information and evidence in that case.
Okay, all right, so it is,
But after his termination,
Inaccurate.
I mean,
okay.
so-
And you really want to talk about the manager's rule, even though we don't,
Even
I
though we
mean,
said the masters that we
you
Explain
go
to me your
ahead.
thoughts, Your Honor.
You go ahead.
I'm interested in your thoughts on the manager's rule, but
You go ahead.
thank you, Your Honor. From our position, the manager's rule should be disregarded, but even if this court were to embrace it for this case, he's followed through with the tightrope that he has to walk to maintain a claim. The manager's rule says that he has to step outside of his position, he has to step outside of his role in order to engage in these protected activities. So you got to look at the facts here. When he has, in November, the conversation with Piscone and Farmer, he's immediately given a performance improvement plan. He's given one with 60 days to improve his performance, and this is after he's never received any counseling, never received...
They started regular meetings with him back in November of 2018 to improve his management.
He contests that that's what that was, Your Honor. But there's certainly...
Does he contest that he yelled at Ms. Farmer on the plant floor back in September?
He did speak with her. He contests that he did not raise his voice to the degree that...
And that he refused to...
How important is to the degree in your sentence?
Yeah.
Well, Your Honor, I think what was clear is that he was terminated in this case for this email that he sent to Giovanni Scafidi. That's why he was let go. It's his email, because he's given a performance improvement plan after this situation.
That may be the ultimate straw.
Right, but he's given the performance improvement plan after the situation with Farmer, and he's given 60 days to improve. And he sends an email. So
Which email, can I just make sure I understand? Which email is it that,
the email was December 11th, 2018, 2 days prior to his termination, to Giovanni Scafini, quote, "We are asking
and
them..."
in that, I understand, I just want to make sure I understand. And in that, your position is that you've alleged that Piscone and other, I mean, they're not copied on that email. Where do we find in the record that the people that fired him were aware of that December 11 email?
Well, Giovanni Scafidi admitted to receiving the email, and it was clear that, again,
No, I know, but he wasn't fired by Scafidi, right? He wasn't fired by Scafidi.
Correct.
He was fired by
Piscone and Farmer.
Right. And so...
So they gave him a 60-day period of time. Those two people gave him
I'm asking a very specific question.
and I'm answering. I'm trying to. Apparently I'm failing, but I'm really trying to,
Were
Your
you
Honor.
finished with your question?
Yeah, no, I think he
Okay.
understands the question. Go
Yes.
ahead.
So the point is that when he's given a 60-day period of time to improve his work performance by Farmer
Yep.
and by Piscone, the
Yep.
people who decided to terminate him,
Yep.
he's not really given 60 days.
Okay.
He's given just a few days. He's
Right.
given, and what happens in the
Totally
interim...
understand that, and that's irrelevant. The question I have, maybe
Right.
you didn't understand it. I thought you did, but maybe not. What is the evidence in the record that Piscone and/or Farmer were aware of Johnson's December 11 email at the time he was fired?
It's circumstantial, and the
I know,
point
but
I'm trying to
what
get
is
to
it?
it. I'm
Yeah.
trying to get to it is that the only thing that occurred between him getting the performance improvement plan, giving him 60 days to improve his performance,
No, Wilkerson's email.
is sending the
Wilkerson's email.
Right.
Like, that's the one we know they know about.
Right.
Right? He's ghostwriting them, probably, but
Right.
that's a different problem.
But I'm
Right? So
just-
it's not the only thing, right? Because Wilkerson's email is on the 12th.
But in the light most favorable to appellant, on December 11th, he
You
emails...
have some evidence, right? And so you said the only thing that happened, and that's false, right? Because obviously
Right.
Wilkerson's email happened too. So what evidence do you have?
Piscone, it's my understanding that when he was terminated, Piscone picked up the email that he had sent to Scafidi, balled it up, and threw it on the table.
Wilkerson's email.
Wilkerson's email. But it was,
So the question is, how did they know about his email on the December 11th?
Your Honor, because it was the only thing that happened between Mr. Johnson and Eldor after he received the performance improvement plan from the individuals who decided that he should be terminated and receive that plan. It's circumstantial. I'm trying to answer your question the best I can.
I understand.
Okay?
I understand.
These are individuals who knew about Mr. Johnson. Mr. Johnson had created quite the uproar at this plan.
I understand your argument. Thank you.
And you have some time in rebuttal.
I do. All right. Well, then I shall reserve it at that point.
All right, thank you. All right, we'll hear from Ms. McCafferty now.
Good morning, Your Honors, and may it please the Court. This case is about a manager's claims that his employees felt overworked and deserved additional compensation or benefits. These claims are not protected activity under the Fair Labor Standards Act because they do not meet the standard articulated by the Supreme Court in Kasten against St. Gobain. Under Kasten, to fall within the anti-retaliation provision of the Act, a complaint must be sufficiently clear and detailed for a reasonable employer to understand it in light of both content and context as an assertion of rights protected by the statute and a call for
Wasn't there, at this stage, isn't there a dispute of fact over whether appellee had fair notice of the FLSA complaint, given that appellant says that he repeatedly told them that, and that, as Judge Benjamin pointed out, the one manager acknowledged that that was the complaint that was being made?
No, because when those statements are read in context, they are not an assertion of rights. I can address the...
What about Helms saying that he was Robert Helms, continuously complaining about overtime?
So in that deposition testimony, the word proper time is being used. Robert Helms wasn't present for any of the plaintiff's statements to upper management. He testified to that. This is all testimony about people saying they discussed overtime, which is meant in its colloquial sense of long hours. Nobody reading the word, when they read or heard these words, meant I need to be paid time and a half for work in excess of 40 hours.
I don't know if Kasten says that they have to say that. And Minor definitely says that he does it.
Well, it has to provide fair notice that it's an assertion of rights.
But
And
what
so-
about the Virginia when he discusses the, in November 2018, he expresses the concerns regarding the Virginia laws and the legality of them working the hours that they're working? Is that not enough
That
from
is-
a non-attorney?
it's not enough.
Okay.
And based on what?
Both the nature of the statement of itself and what he said afterwards.
So him saying, I'm not sure if what we're doing is legal under Virginia laws in terms of the hours that these guys or ladies are working, is under what context are you taking that?
No, that's correct. If they say, I'm not sure, or we might be breaking the law, that's not an assertion of rights and a call for their protection. So I just want to read the statement, and I'll back up a little bit. One thing I struggled with in preparing in this case is identifying the statements that the plaintiff claims amount to complaints. And I arrived at, there are three. One is the one the court is asking about. The other is the email on December 11th, 2018. And the third is a statement that the district court addressed in its opinion. So I'll move through each statement, but I'll start with the November 2018 statement. The statement is, he claims that in a meeting, he brought up that he'd found the legality in Virginia to be, you can't work a non-engineer over 40 hours without some kind of compensation. He then described what he meant by some kind of compensation, and he proposed options. Options are the plaintiff's words. He proposed paying time and a half for work over 50 hours, adding to a flex time bank, or creating a 4-hour minimum for a call-in. By using the word options to describe his compensation proposal and requesting benefits like flex time, the plaintiff communicated that the legal issue he had identified could be addressed in a variety of ways and that paying a specific rate of compensation was not required. A reasonable employer who heard this statement would not conclude the plaintiff was asserting rights and making a call for their protection. So that's the November 2018 statement. The other key statement that the plaintiff relies on is the December 11, 2018 email. An employer would not understand this email as a complaint under the Act, primarily because the plaintiff states in the email that his concern is with employee happiness. He begins the email by saying, "I'm writing to inform you of the current situation," and then explains, "My concern is with employee expectations and employee happiness." That statement makes clear that the purpose of the email is to address employees' well-being. And if the court would like to follow along, I'm looking at page 190 of the appendix. An employer reading it would understand everything that follows with that purpose in mind. The plaintiff goes on to say that his team is being asked to work many hours of overtime without a hint of compensation. We are asking them to come in early, stay late, be on call, and run the line. As I have pointed out many times, overtime, staying late, all of these things are expected, but expected to come and go and not be steadily high. So that's one of the statements the plaintiff relies upon. Reading that, overtime is being used in the colloquial sense of long hours or hours that one normally would not work, coming in on a weekend or at night, something outside of their regular shift. He claims that just the word overtime itself signals he was trying to say that his employer needed to pay his employees time and a half for work in excess of 40 hours. No one would...
With that, I mean, maybe not for those of us with legal minds, but overtime I would think most people would think, right? If you say overtime, that they're going to get paid for overtime?
No, I disagree with that. I think overtime in the ordinary sense is long hours, hard work, more than you should be doing. It doesn't necessarily mean anything about pay. And I mean, the entire thrust of the statement is that they deserve more pay, not that they're legally required to get it. And I think
Weren't the employees that he hired exempt from overtime?
that's correct. He testified to that.
That's correct, yeah, that's what I thought.
That literally, it's like, it's a mind meld here. Right, so, is there any record that he was hiring or had a team that was with non-exempt employees?
Not that I know of.
Right, so, I mean, that strikes me as an odd line for him to be drawing, right? Because the record, at least as I see it, is unambiguous, and that he was hiring engineers, and he was an engineering team, and that they were all exempt. And so that context seems to matter to me.
That context matters. I would love to argue it's dispositive, but still, it would be theoretically possible for him to make a statement that nonetheless put his employer on notice. But yes.
Of course he could. He could say, Bob Smith's team over here of employees are working overtime, and that's against Virginia law. Do something about it, right? That makes sense to me, but we sort of look at these things in context as to what fair notice would provide.
That's correct, and it says quite a bit about what the plaintiff could have been communicating. If he knows his employees are exempt, it makes it very difficult for him to also believe there's a violation of the Fair Labor Standards Act and that he's communicating that by his statements.
Can I ask, your colleague wanted to talk about it, and maybe he will on reply, but the manager's rule, and all these manager's rule cases sort of predate Kasten. Can you tell me why I don't think about the manager's rule as it's formulated as really a way to understand Kasten, right? The Kasten itself is just saying you got to have fair notice, and fair notice looks a little bit different when you're getting information from an HR director than it is if you're getting it from a line employee, right? That the fair notice standard of Caston is, like, eliminates the need to really talk about the manager's rule, because it's not a standalone rule, it's just part of this idea of what would provide fair notice in an objective sense.
I believe I agree with this.
Okay.
I view the manager's rule as a context-specific application of the Caston standard to managers. It explains how a manager provides fair notice of a complaint under the Act when the conduct that they claim is protected is part of their ordinary job duties. Because in those circumstances, if you're saying that something you ordinarily do is protected, it's impossible for that to provide fair notice.
Well,
That-
explain how it's workable, because I think that was some of the concern in the masters. How is the manager's rule workable?
In
Give me an
DeMast-
example of how it works for the manager to step out of the role and make this complaint.
In DeMasters, this court expressly left open whether the manager's rule would apply in the Fair Labor Standards context. What would it look like to step outside of the role? Something that makes clear they are no longer performing their job duties, and what they are doing is trying to assert a complaint about a violation of rights. So it really would have to be pretty clear. But, I mean, let's take me in.
But how would they do that? They would have to say, I am now stepping out of my job duties and asserting a complaint?
They could say, I don't think the company is doing enough about this, and I'm going to contact the Department of Labor. I
They
think
wouldn't
that's
have
the
to
right
do
thing to
that
do.
much, right? So imagine an HR director. An HR director says, you know, my law clerk, Alan, he's complaining. He goes to the HR director. The HR director says, Alan says that he's complaining about his overtime. Now, she's just conveying information. She's not asserting a violation. The same HR director might instead turn around and be like, Alan's asserting this problem, and I think you're violating the Fair Labor Standards Act, and you need to do something about it, right? So the first one is sort of in her role as the HR director, and the second one is an assertion of a right, right? I'm not just reporting what's happening here. I'm not providing information. I now have become, in essence, an advocate as to the action. And in those instances, you would agree the latter instance would be an FLSA assertion, and the former would not be.
That's correct.
And that's Caston, regardless of whether we really look at the quote-unquote manager's rule, which all of those cases predate Caston.
That's correct. The other thing that's important to note about the manager's rule is that it was a secondary basis for the district court's decision to grant summary judgment. The district court wrote a 25-page opinion. Only 2 to 3 pages are on the manager's rule. So even if this court disagrees with everything that the court said about the manager's rule, it should still affirm because the statements do not provide fair notice. And I'm going to move back to the email because as I understand it, there's 3 statements that the plaintiff claims are complaints.
Can you talk about the Scafidi testimony that Judge Benjamin
Yes.
mentioned, that he understood Johnson to be emailing about paying overtime?
Yes, I would like.
And 2 questions about it, maybe in sort of context. One, does his subjective view matter, or is this under Caston just an objective inquiry? And then 2, how am I supposed to understand that testimony?
It's an objective standard, so it's what a reasonable employer would understand. Potentially, a subjective view could militate one way or the other. It could suggest, if someone subjectively doesn't understand it that way, it could suggest objectively it just doesn't mean that. But I would like to
And
read.
where was Scafidi located?
He resides in Italy. He is the chief operating officer of Eldor's parent company. So the testimony that was referenced.
But he's referencing the email he got, so, right?
This is the line of questioning. This is
Yeah.
on Joint Appendix 1010. And this is a question from counsel. Okay, December 11th. Now, in the second paragraph of this email, there's a sentence, and I'm going to read it to you. It's about midway through. I heard you read it. It says, You're asking my group to alternate between first and second shift. We are asking them to work many hours of overtime without a hint of compensation. Do you see that? Mr. Scafidi answers yes. Okay, so isn't Mr. Johnson reporting to you that there are workers who maybe should be paid overtime but weren't being paid overtime? And he answers, in this mail, yes, we are asking men to work many hours of overtime without a hint of compensation. Yes, his summation of that people working, yes, that time. That's disjointed because that's how the answer was. So even just looking at the question, who maybe should be paid overtime, there needs to be an assertion of rights and a call for their protection. If it's a question of maybe, it doesn't qualify as a complaint. And really, what Mr. Scafidi is doing, he's just agreeing that the email contains that sentence, if you look at his answer. He's not saying that he understood it as meaning that there was a legally required rate of pay that needed to be given to certain employees.
But in terms of notice.
Right, so that also would not give notice. Overtime in that sentence is being used in the colloquial sense. That's in the second paragraph of the December 2011 email.
So can I pause you a second before you turn to that email? I asked your counsel about this, or your colleague, and I'll ask you too. Is there any evidence in the record that Johnson's December 11th email was made known to Piscone or Farmer before he was fired?
Not that I know of.
And is there any evidence that Scafidi ordered Piscone or Farmer to fire? I mean, Piscone and Farmer were the individuals who fired him.
That's correct.
Right, not Scafidi.
Correct.
And so to consider whether this was, protected activity that would cause something, don't we have to have some evidence, the plaintiff has to put forward some evidence that the decision maker was aware of this? I mean, if Scafidi knew about it, but the decision maker here, Piscone/Farmer, did not know about it, then it cannot have been the reason for his firing, right?
I agree with that. I mean, it goes to a separate element of, the main question here is, did he engage in protected conduct? And that's really a causation argument, but we completely agree with all of that.
Right, but we have to look at, it's hard to look at those totally separately, right? I mean, nobody would make the argument, or I think nobody would make the argument, the fact that he told his wife about this, that's protected activity, right? So if he didn't tell the decision maker, we shouldn't consider it, right?
That's correct. But it sounds like there's a lot of concern about whether this use of overtime could potentially put an employer on notice. And this is in the December 11th email. So after he makes these statements about overtime, the next paragraph he writes, if at all possible, I need some measure of relief for the group. Before you left, we met regarding a compensation idea I proposed. No movement has been made regarding this idea. I need this or something like it to be a priority to succeed at my job. That's what follows the statements about my employers are working overtime.
Well, what is this document? What is this document on JA 707 to 708? It's Exhibit 34 to one of the depositions. It starts out, Eldor has been poorly staffed until recently. And I think it's described in one of the briefs as something that appellant wrote after the fact, documenting everything that occurred.
I don't have that specific document handy, but that's great. After everything occurred, there's no dispute that Eldor was understaffed. Some of our witnesses...
But this, so I know you don't have it in front of you, but this document, if you're familiar with it, it's something that appellant wrote?
He wrote a summary of the reasons he was
Okay.
terminated after.
Because I'm looking at that summary of the reasons he was terminated and the suggestions and things he made, and all of the suggestions he made seemed to kick in after they worked 60 hours, which would not, even in his own words, after the fact, indicate that this is an overtime FLSA issue, correct?
Correct. To conclude, the district court correctly granted summary judgment because the plaintiff never engaged in protected activities. He complained that his team was overworked and felt taken advantage of, but he never engaged in conduct that amounted to the filing of a complaint under the Fair Labor Standards Act. For that reason, Eldor respectfully requests that the court affirm the judgment of the district court. I have 30 seconds, I'll answer. Any other questions?
I don't think we have any. Thank you. We'll hear from Mr. Strelka again.
Thank you, Your Honors.
Okay.
Again,
Can you start with Judge Thacker's question, which I paraphrased to say, where in the record can I look to find that Johnson's team employed a non-exempt, non-engineer?
right. So first off, the
Start
issue
with where in the record I should look,
Well-
and then explain whatever you want me to look.
that issue is not clearly, I would say, I don't have that information right at my fingertips. But I would like to talk about it, though. And the reason is because the issue of whether these, quote, engineers should have been even exempt or not was a key issue at the time. There were individuals that were called engineers by management who, under, again, a lawyer's perspective of analysis of all of the information, this is what the other
Let me
lawsuits...
ask it more precisely. Is there anything in the record, just that you can tell me about?
Right.
I can get somebody to find it in the record since you don't have it, but
Right.
that he hired and his team were non-engineers.
It was the plaintiff's position that these individuals were owed overtime. It is...
Okay, I'm asking a
Right.
very specific question, and if you could help me.
It's not in the
If you
record.
don't want to help me, that's totally fine.
It's not in the record, but the court may make an incorrect assumption that just because the employer says that they are exempt
I'm sorry,
means
it's
that...
not in the record. So what you're saying is, you agree that, at least as far as the record goes, that his team was entirely made of engineers?
Correct, but this was not a determinative
And
issue.
he testified that the people that he hired were exempt from the FLSA,
According to the documentation from Eldor, according to how they classified
according to
them.
his testimony.
Right, but he was mirroring what was told to him about these workers. And
Did he
this...
say that in his testimony?
No, but this...
Okay, all right. Well, then, let's get back to the record.
Right. The issue about whether those workers were exempt or non-exempt was not a determinate issue at the district court level. It wasn't. And one of the reasons for that is because when a employee...
It wasn't a I don't understand that. What is it?
The issue that you've highlighted, Your Honor, the fact that he's working with these workers who are engineers, whether they are exempt or non-exempt, is irrelevant to whether or not he engaged in a protected activity in this case. That's what I'm saying. It is. It strictly is. Because it...
I understand that argument. I just want to make sure I understood the record, because I thought the first time you were up, I asked you about this question.
All right.
And you suggested to me that he had employees on his team.
Right. Your Honor,
And
he
so-
did. Again, this is a separate lawsuit. Again, it's not on the record. Not on the record, y'all.
I don't want to hear it if it's not in the record.
All right, well then, but the issue of whether these engineers were exempt or not was something that was
But you
litigated.
wrote in your brief that his complaint led to a separate FLSA collective.
Post his termination.
Right, but with no JA site there either.
It's just a reference to it, Your Honor. There's something important, Judge Richardson, I want to circle back to you about the notice issue with Scafidi, okay? If you take that entire, well, forget it, don't take it out of context. Just say that Scafidi never had notice, or that Scafidi never talked to Piscone and Farmer. Let's say that. Let's assume that. Let's assume Scafidi gets this email.
This is the December 11 email?
December 11th email.
Okay.
He reads it. It may have some overtime stuff in it. It may be protected. It may be not. But in this hypothetical that I'm presenting, he doesn't present this information to Piscone or Farmer, okay? Well, he still has an FLSA retaliation case because 1 month earlier, he did highlight protected acts to Farmer and Piscone in November. And due to temporal proximity, even if the whole thing regarding Scafidi is thrown into the trash.
The question is just whether, right, the question is whether we consider the December 11th email or
Right.
not.
Right.
Right? It's not, I understand that you have an argument about the October, November testimony that he says that he said.
Correct.
Right? But we're trying to look at the pieces of the puzzle.
Sure.
And your
That email's-
suggestion that this is all about the email of December 11 seems belied by the record.
My point I'd like to make now, Your Honor, is that if the court is of the mind that there's no evidence tying that email to the decision makers, it's not needed. Because those same decision makers were in the room with the plaintiff, the appellant, when they heard his protected activity 1 month before they decided to terminate him. Under every single precedent that this court has regarding temporal proximity, he satisfies it.
But then it's only about the meeting, right? Then we have to gather fair notice from the meeting alone.
Which you can. Yeah. And
And how is that fair notice from the meeting? The November meeting, not,
because in the meeting, according to his testimony, in the light most favorable plaintiff, I brought up to Fabio Piscone that I'd found the legality in Virginia being you can't work a non-engineer over 40 hours without some compensation. That's what he said in the meeting, 1 month prior to his termination, and just days before these same individuals gave him a performance improvement plan, telling him he had 2 months to fix it, and then they didn't give him the 2 months. So I think circumstantially in the light most favorable to appellant, the fact that he sends an email to the highest person that he knows in the company, of an Italian company in Italy, I think it'd be unusual for that person not to communicate that back to his U.S. managers. But again, I don't have the evidence of that email, or it is what it is. But thank you for your time. We ask that the court reverse the lower court's decision. Absent the question of law related to the manager's rule, a reasonable jury could find that this individual engaged in protected activities, that they knew it, and they retaliated against them. Thank you.
Thank you. We'll come down and greet counsel and then take a brief recess.
This honorable court will take a brief recess.
All right, thank you. You're going to introduce student council?
Yes, good morning. May it please the court, my name is Erica Hashimoto, and I'm court-appointed counsel for Mr. Patel. With the court's permission, third-year law student Madeline Brown from the Georgetown Appellate Litigation Clinic will be presenting argument on behalf of Mr. Patel.
Great, thank you. Whenever you're ready, Ms. Brown.
May it please the court. The government has demonstrated a complete lack of care in following procedure, thereby destroying Mr. Patel's career. Mr. Patel's former private employer uploaded an unverified incident report onto a government database, and the government has shared the existence of that report with other private employers, cutting Mr. Patel off from his field of employment. Failing to maintain only such information in the JPAS system as is relevant and necessary to accomplish the purpose of the Department of Defense, the DoD is violating Mr. Patel's rights under the Privacy Act. The government...
Under the Privacy Act, how do you get around the Egan opinion?
The government had no hand in generating or investigating this report. Moreover, there's nothing in the record suggesting that the incident report was used for anything, let alone a security clearance. And Egan is a case focused on a security clearance decision that the government is using to prevent the courts from hearing Mr. Patel's claims.
Do you agree that Egan extends beyond the decision itself, sort of upstream into the process of making that decision?
I do agree in instances, for example, in the case of Mallory,
And
Egan.
Becerra, right? So those are examples of upstream in the process, right? So that's the investigation or the psychological evaluation?
Yes, sir.
And that's part of the process, and it's upstream of the decision. So it's not limited to the decision itself. It includes the process?
Yes, Your Honor.
So why do I not consider the gathering of information, as in Becerra, an investigation, the gathering of information in a database, why is that not part of the process, just like in Becerra, just like in Mallory, that ultimately leads to the predictive judgment? I admit we have no predictive judgment being made here as far as Egan goes, but this is part of the process for making that predictive judgment.
There is a distinction between the initiation of a security investigation, and in this case, there is nothing in the record indicating that the government has used or vetted this information in any way. Moreover, in the case like Becerra, it was investigating the plaintiff regarding his security clearance. In Mallory, it was investigating an individual regarding...
Both of those are decisions by the government to gather information, right?
Yes.
I mean, that's what an investigation is we've made a decision to gather information. And the Army or not just the Army, but the government has made a decision to also gather information in the JPAS system, right? And it is upstream of the ultimate decision, just like an investigation is upstream of the ultimate decision. But why isn't that part of the process in the same way that an investigation is? Both of them are examples of the government gathering information to use to make the ultimate decision, right? That would be the Egan choice.
Your Honor, I think it comes down to the government's ownership of the information, and that in Becerra and Mallory, it was the government creating these questionnaires or creating this information. In our case, it was a former employer called Credence who submitted this incident report, and these facts in the incident report are alleged, and they have not been verified by Mr. Patel or, to our knowledge, by the government in any way.
But once the report's submitted to the government, But the government owns it, right? It's not like it doesn't belong to somebody else, right? It was given to the government, right? So when you file a brief with this court, you filed it, it came to my office, it now belongs to the Fourth Circuit, not you. Like, you can't come to my office and take it back, right? So it's mine, or my court's at least, right? So it's not an ownership, it doesn't seem like to me, but they both seem to be forms, ways of gathering information. That's what I'm trying to understand is why I think of these two different sets of decisions for gathering information, why I should think of them differently.
In both Becerra and Mowry, the government made a clearance-related decision concerning the individual, in that there's no clearance-related decision that has been made regarding Mr. Patel. The government agrees that his security clearance has never been in question. So,
But doesn't Mr. Patel, even in his complaint, and granted, I know it was pro se complaint, but doesn't he even say that he was investigated in his complaint? I think it's like I have 8, 9, where throughout the complaint, he's saying that the Army was investigating him based on, and he goes through all of these reasons why. But he even thinks that there's some investigation going on here, right?
Mr. Patel may have believed at that point there was an investigation, but after our review of the joint appendix and what's on the record, there's no clear facts pointing to even the initiation of any government investigation
So
here.
what's on the record is that he alleged that in the complaint, as Judge Benjamin said. Doesn't that matter? I mean, it's what he said. It's what started this whole thing.
Yes, I'm not sure that if that verifies, though, that there has in fact been an investigation. Moreover, there's not that tied to national
So we
security.
can't take the allegations in his complaint as true?
My apologies, Your Honor. We should take the allegations as true in his complaint. But
What, for your Privacy Act claim, what's the remedy that you seek?
in regards to this court, we ask the court to hold that Egan does not bar Mr. Patel's claims and to remand back to the district court to decide on the merits of the claim.
And if the district court were to get to the merits, what do you think the district court can do? Can the district court, like, line edit the JPass system? Just sort of get a printout and he takes a red pen and the district court goes through and does, like, what do you want the district court to do?
We're asking the district court to require the government to look at whether they complied with the Privacy Act, and we do not know exactly, because there has not been discovery in this case. Mr. Patel has no way to know exactly what employers are seeing in the JPass system, but we are requesting compliance with the Privacy Act and to fix any violations of the Privacy Act. We're not.
So when you say fix, so if I assume for a minute that you have a violation of the Privacy Act, just accept it for a second, I guess what I'm trying to understand is, what is it that you want the district court to do? Right? So what would the district court, there's a violation of the Privacy Act, whatever that looks like, with respect to the records that are in the JPass. What is the district court to do? In other words, how is this, like, redressable?
We're asking the district court to ask the Department of Defense in this case to comply with the Privacy Act. So there are allegations in the incident report that's in the JPass that Mr. Patel, and facts in there that Mr. Patel believes are not true, and we would ask the DOD to go in and fix those facts like they did in Reinbold, for example.
Okay, so the district court would order the Army to edit the information in the database.
Yes, the Department of Defense, yes, Your Honor.
Right, the Department of
Yes.
Defense I keep doing that, that's my fault. And so, and you think that doesn't implicate Egan when what the Department of Defense says is that all information in there is to be considered for determining whether security clearance exists. I mean, the challenge is, like what you're saying is, we want the district court to order that the Department of Defense cannot consider some information in making the predictive judgment. That's what you're asking the district court to order. This is information that that Department of Defense cannot consider when making the predictive judgment.
We're not asking them to not consider the information, we're asking them to verify the information.
Well, you
the
said to delete it.
veracity.
You're saying to delete what you allege to be, irrelevant and unnecessary information, right?
Yes, Your Honor.
Based on, I assume, the district court's judgment as to what is necessary and relevant to determining whether security clearance is appropriate? So the district court gets to decide what's relevant to whether you get a national security clearance.
Yes, and there's also DOD guidance to refer to, like on the DOD website.
Wait, but you said yes, in answer to Judge Richardson's question, you said yes, the district court gets to decide what's relevant for security clearance purposes. Isn't that directly at odds with Egan?
Yes, so my apologies. The district court cannot decide directly security clearance decisions, but we believe that the information in the JPAS system, which is a repository of employment information, is not directly bearing on an individual's security clearance. An employer can submit anything into JPAS that's adverse to their employee.
But you agree that what you're asking is the district court to require the Department of Defense to delete information from its database on the basis that the district court believes it, I think you started off by saying, that it is irrelevant and unnecessary to the national security determination that would ultimately be made.
Yes, Your Honor. Mr. Patel has not had discovery, and he is facing ongoing harms from the action of the government. After having multiple job offers revoked and emails dismissed, Mr. Patel had to file a lawsuit here to figure out what was going on. For purposes of 12b1 subject matter jurisdiction, this is a narrow inquiry. Egan prevents courts from second-guessing executive branch decisions about national security clearance. The district court mistakenly characterizes Mr. Patel's claim as challenging a national security decision, as challenging a security clearance decision, and thereby...
Your APA claim, do you concede that that was brought for the first time on appeal, the APA claim?
No, Your Honor. Mr. Patel invoked the APA in his pleading when he used distinct language and concepts of the APA, such as arbitrary and unpredictable, and then in his response to the motion to dismiss, he further clarified using language like arbitrary and capricious.
So using language like arbitrary and capricious means that he invoked the APA? Did he invoke it specifically in his complaint anywhere?
Mr. Patel further alleged that there's been more, in addition to using the language, he challenged the actions of an agency and invoked the APA by challenging the government's failure to give him proper procedures. He did not use the words.
The challenge with that, and it sort of raises an interesting question. We do give pro se complaints a liberal construction, but we contrast that with the Supreme Court's repeated guidance that there is a party presentation principle. And so we don't get to make up claims, right? We can give it a liberal construction, right? But we can't make things up. And the language you cite to, in paragraph 31 of the complaint, it falls in a count that your client identified as violates plaintiff's procedural due process rights. Don't I have to like read that out of the complaint to understand him to have been raising an APA claim? I mean, because it is relevant to a procedural due process claim, maybe, that the agency didn't follow its own regulations, right? So that's pertinent to a procedural due process claim under the Constitution. But it's really hard to read that as making a like separate complaint that's not procedural due process.
Mr. Patel also states that he is, quote, is suing a federal agency based on its decision, and he requests a permanent injunction prohibiting the government's revocation of his access card.
So the court is supposed to give him back his access card by
No,
way of this injunction?
we're asking for Mr. Patel to receive the process he was due, including a right to appeal the revocation of his access card here, not to receive back the access card.
Not right away, at least. After due process, you would argue that if it turns out in his favor, then he gets the access card back.
So I don't understand that. So because you say, at least, or your client says, issue a permanent injunction prohibiting the defendants from enforcing the decision to revoke the CAC. Right? So that if they can't enforce the revocation, that means he has it again. Right? That's the like negative implication. Right? So, I mean, he's asked to like have the district court decide that this information is not relevant to national security decisions and that he should have access to this particular facility.
Well, in regards to the access card, the government has conceded that the Egan bar wouldn't apply, so we're not asking for the connect. Oh, Your Honor, is it okay if I continue
Please.
speaking? My apologies. Could you just repeat?
Yeah, the question is, help me understand on the access card, what you would have the district court order? Like what relief do you think the district court could order? I mean, I think you seem to acknowledge, regardless of what's asked for in the complaint, that you cannot have the district court like grant an access card, right? He can't go print one off and hand it out, or order the DOD to do so. So what is it that you think the district court, if you established your claim, should do here?
We would like the district court to ask the Army to follow its own regulations by giving Mr. Patel a chance to respond to and appeal the decision. And as Your Honor previously said, if the agency cannot follow their own process, then might have to at some point stop blocking Mr. Patel's access to his CAC, his Common Access Card.
Okay.
Anything else? All right, thank you. Ms. Brown, you have some time in rebuttal, and we'll hear from Mr. Baumhart.
Good morning. May it please the court. Assistant U.S. Attorney Peter Baumhart on behalf of the defendants. In this case, plaintiff wants a court to dictate what information the Department of Defense may consider in investigating and adjudicating a security clearance. But the Supreme Court and this court have been clear that the separation of powers prevents a court from interfering with how an agency makes predictive judgments about access to classified
But I
material.
think what appellant just wants is for the Department of Defense to follow its own procedures before, or at least that's their argument, before revoking the access card. So how does that require any judicial review of security clearance determinations?
So, Your Honor, I want to make clear that there are two actions here taken by two different entities that are subject to two different doctrines that preclude judicial review. The point about the access card is subject to cafeteria workers rather than Egan. Egan and this court's decisions construing Egan have acknowledged this sort of pure process type claim, but cafeteria workers doesn't. Cafeteria workers itself was a due process claim based on summary exclusion and revocation of an access card. And so the regulations that plaintiff has been referring to, there is no pure process claim exception to the cafeteria workers bar. That would only be under Egan. And the Army's process for revoking the CAC is not.
Well, but in cafeteria workers, the court said that it had followed the process, right? And certainly says that the Constitution provides no process, right? But why, assuming for a minute that it was properly presented, why couldn't there be a claim under the APA that you don't have to have process, but if you decide to create process, you got to follow it?
Well, I don't think that there would be an issue with that sort of claim, but I would point out that the very regulations that plaintiff relies on for this due process, or the process type claim, actually exempt, well, let me back up for 1 second.
Well, I understand your merits argument, and
Yeah.
you might well be totally right. This is is it F3? I totally get that argument, but we're not asking the merits question, right? We got to ask this threshold question.
No, I understand, Your Honor, I'm sorry. The point I was trying to make is that obviously we think that the record is clear that the Army never revoked his CAC. It just required its return upon his exclusion from the Polk building as part of normal checkout procedures, and that was explained in our brief. But even,
So what-
I'm sorry.
So the February 20th, 2020 letter suggests to me that they revoked the CAC?
This is the one from the Army to Gallarath?
Yes.
So that's an important letter because it actually doesn't say that his CAC was revoked. It says that his CAC was required to be returned. Now, there's a few ways that a CAC...
I mean, I get, we slice things thin, but...
No, but it is important because the regulations that plaintiff is referring to refer to when an adverse credentialing determination has been made that the person is unsuitable to hold a CAC. But when, for instance, someone is separated from employment, they are required to return their CAC without any sort of adverse credentialing determination being made. Just as
Except
part
that
of
the incident report, is the incident report still on the JPAS?
The incident report is still in JPAS.
And yet his security clearance hasn't been revoked and the CAC hasn't been revoked, it was just returned?
That's right, Your Honor. So
what's the basis for maintaining the incident report on the JPAS?
the incident report is there solely for review and a future clearance determination. And I want to make clear that what happened here factually is that the IR was submitted, I believe, on February 14th. He was terminated by Gallarath on February 21st. In that time, the Army did not, or excuse me, the Department of Defense, I have to make clear to keep those separate. The Department of Defense had not investigated the IR, but it then lost the ability to do so because the DOD may only investigate and adjudicate incident reports when a clearance is needed.
But then why shouldn't appellant be afforded some due process before this incident report is maintained on the JPAS when his security clearance hasn't been revoked and his CAC hasn't been revoked?
So
It's just out there with anybody for a negative implication for any future employer.
Well, so the IR itself, the substance of the IR, is my understanding is it is not viewable to anyone but DOD and whoever his employer is. Anyone else who is using JPAS would only see that there's an
Future
unadjudicated-
employers.
Excuse me, yes.
Yeah,
Future
so that's a problem for him. So why isn't he entitled to due process before that's just maintained on there for?
So I think there's a bit of a mismatch on the due process part, is that
Okay.
plaintiff has never, the only regulation or process the plaintiff has identified regarding the IR is this guidance that is issued to contractors about, how they are supposed to use JPAS. And the idea that there's no process before the IR is just simply held on JPAS, the process would be the government investigates the IR and ultimately makes a decision on it. And they have not been able to do that because DOD only has authority to investigate and adjudicate incident reports when a clearance is needed, such as when a person is employed or has an offer.
He wouldn't be employed or get an offer, would he? Because when he applies to federal contractors, they would see this incident report that hasn't been validated.
It hasn't been adjudicated. It's hard to see how the a DOD could validate it without investigating
Okay,
it.
adjudicated or investigated. It's just out there with this negative inference for future, that future employers would see. So I don't see how he'd ever get a job.
So there's a kind of peculiar factual scenario here because Egan most often comes up when federal employees have had their clearance investigated or have had an adverse action taken against their clearance. And here, the investigation would have followed but for the fact that his private employer terminated him and thereby deprived DOD of the ability to investigate and make a decision one way or the other, whether it merited any action on his clearance or not. And so the idea is that, where the idea of why process before the DOD can consider it comes in is Egan, is that this is something that the DOD has to decide. They are the specialized decision makers with expertise in making these clearance decisions. And if Egan stands for anything, it's that a court lacks that competence to make.
But for the JPAS, I understand the due process argument, but why don't we look at the Privacy Act as sort of Congress's effort to do what Judge Thacker has suggested here, right? I mean, the Privacy Act says basically this, right? That like if you got records about somebody in the federal government, I'm obviously grossly simplifying, then you get a chance to make them accurate.
So I'm just on the Privacy Act itself, leaving aside the Egan issue. The Privacy Act has a very limited remedy, and there is a noted fact and opinion distinction that is laid out in Reinbold.
All right, but you want to talk about the merits of the Privacy Act. We're not going to reach the merits here, right? Mm-hmm. Except for a second that your alternative arguments on the merits are not what we're talking about. What I'm trying to ask is the question of, does the Privacy Act claim exist, right? Because it was dismissed at a 12B1, right, that this is Egan barred. But Egan leaves open this idea, maybe, that where there's like congressional authorization, it might look different.
Well, so
here's congressional authorization, right? This is a Privacy Act, and that authorization allows you to like go in and correct your records.
So I believe I understand the part of Egan you're referring to, and it would require specific congressional authorization to.
Tell me why specific, why this is not specific.
To adjudicate within the security clearance context. The Privacy Act doesn't say anything about the security clearance context. It's similar to how this court has declined to find such congressional authorization in Title VII, the Whistleblower Protection Act, a couple other statutes. And there's actually a regulation that specifically which we cited in our brief, specifically exempts documents used in the security clearance adjudication process from amendment or under the Privacy Act.
So two questions. One, if I wanted to say that the JPAS system is for the national security clearance process, how do I know that based on the record?
I believe there's a few cases that we cited that recognize this, and there was a JA site that I think was to a letter that was sent by a DOD entity that recognizes that fact.
And then, so your point is that the word specific that I left out the first time, the word specific in that context would mean you would need an act that says what the Privacy Act says, but specific to like JPAS or information relevant to national security.
I believe that is the upshot of Egan and this court's decisions in Guyot and Campbell and I'm forgetting the third one, but it has to be a very clear statement by Congress that this is meant to interfere with the security clearance arena.
So in practice, what does all this mean for appellant? What happens or would happen if he seeks employment with another federal contractor that requires security clearance? And this is hanging out there.
If he obtains employment with...
Well, before how's he going to obtain, that's what I don't understand. How is he going to obtain employment with this incident report on the JPAS? Wouldn't they just see that and go, oh, red flag?
Your Honor, I don't necessarily believe so. There's nothing certainly alleged in the complaint that this is like a death knell within the defense contracting industry. I mean, he has alleged that specific jobs he's lost, but
Right, he's lost jobs already.
well, so the Gallowrath job was because he could no longer access his work site, so he couldn't perform the work that he was hired to do. The loss of the second job, I believe, is the only thing alleged in the complaint is that it resulted from sort of unspecified DOD contact.
Which is a good, I mean, it's not unreasonable to assume that that unspecified DOD contact was, oh, this incident report's in the JPAS, so we're not going to deal with this.
Well, respectfully, Your Honor, I would see DOD contact as some sort of reaching out by DOD as opposed to just passively viewing this thing.
Can I ask,
Yes.
maybe I'm not understanding this, maybe, let me back up just a second, very simply. So if I wanted to, if I was a contractor and I wanted to hire Mr. Patel, do I get, as a contractor, do I get access to what's in the JPAS system?
So this specific answer I don't believe is in the record, and my understanding is that the substance of the IR would only be viewable to the employer of the person whose account it is. And so another.
It is viewable by at least an employer, maybe not a prospective employer, but at least
Right.
an employer
Right.
would be able to access, and that seems remarkable to me, that a federal contractor can look at all of the records in the JPAS about its employee?
I believe so, Your Honor. It has to put up these people for clearances and sponsor them for clearances. So I think they would want to know sort of what they're not necessarily up against, but what the relevant information is.
But you
before they
don't
do
know
that.
if a prospective employer who is a national or a federal contractor has access to the JPAS.
My understanding is that, and I don't know if this changes in the prospective employer context, but that anyone other than the actual employer would see only that there's an unadjudicated event. And
Unadjudicated event sounds pretty bad to a prospective employer
so
when they have no idea what that unadjudicated event in the DOD system is, for which he lost his CAC.
well, so the CAC, the CAC, again, is
Just
sort of
because he can't go
separate
in
from.
that, I understand your
the IR.
distinction there. It's not, didn't lose his security clearance. I don't know, it just seems, it just seems pretty challenging for Mr. Patel to get federal contractor employment again with this in the system unresolved.
Well, it's sort of, again, it's fallen into this sort of lacuna of the DOD's authority. In the ordinary course, had he remained employed, the DOD would have investigated it. It just merely lacks the authority to investigate. And to, I believe, the point that Judge Richardson was making, the only way that it would require a court to go in and say that this is really necessary or relevant to a security clearance determination, which is, I think, the heartland of what Egan says courts can't do.
So when he's seeking, for lack of a better, when he's seeking process, the process under DOD's regulations would not be in place until after, if he ever got another offer of employment from a federal contractor.
That's
And
when
then they sought
I'm sorry.
security clearance for him.
Correct. That's when the adjudication of the IR would occur. And again, I want to distinguish because the process argument is largely tied to the Army's regulations about revocation, adverse credentialing determinations with respect to a CAC. And again, the only regulation cited with respect to the IR is not even a regulation, it's guidance to contractors, which is non-binding on DOD. And DOD's obligations are instead set out in the controlling executive order, which requires agencies to maintain potentially relevant information for a clearance in the person's file.
Earlier you were about to talk about Reinbold.
I'm sorry?
Reinbold?
Oh, Reinbold.
Yeah, so how is, because that deals with the Privacy Act. That case deals with, so I'm just curious as to what, I think we cut you off, you were about to talk about Reinbold.
So
It relates to this case.
yeah, the plaintiff has argued that Reinbold deals with the interplay between Egan and the Privacy Act, and I respectfully disagree. Of course, unlike here, the Privacy Act claim in Reinbold did not challenge any documents that were used or were likely to be used in the future against the plaintiff's clearance. They postdated the suspension of his clearance, and then there was a proposed permanent revocation of his clearance that was overturned on administrative appeal. And that decision meant that the challenged documents, in fact, did not warrant any action against his clearance, which would effectively rule out them being so used in the future. So again, unlike the facts we have here, where it's clear in the record at JA 54 that the IR will be adjudicated in a future clearance investigation.
So I thought your argument on Reinbold was going to be that it was decided before Steele Co., right? And so we now have this like strict order of operations that we have to address jurisdictional issues before we address the merits. But pre-Steele Co., courts, including this one, sort of had the belief that we could decide the easy question, and so we shouldn't infer from Reinbold's rejection of the claim on the merits that it had any view on the jurisdictional decision.
So, Your Honor, I think obviously we would have, been happy to make that argument. But the issue is that I don't know that there's any indication in Reinbold itself that an Egan argument was raised with respect to the Privacy Act, because the court did deal with the Egan issue with respect to the plaintiff's Bivens claims in that case, which actually incidentally supports our point that Egan does apply to constitutional claims.
The point being is that we can't draw an inference that the court considered and rejected the jurisdictional argument of Egan because it wasn't required to do so.
Oh, Your Honor, so on that point, yes, we would agree that Reinbold certainly didn't reject any Egan argument. And our view is just that the reason that it didn't seem to address Egan in the context was that there was a reason why it seems like Egan may not have even applied, which is that those documents.
But that's an assumption on top of an assumption, right? Our point is we don't know whether the court considered it at all because it was perfectly entitled at that point in time to address the merits, which were straightforward rather than the jurisdictional question.
That is fair, Your Honor, and I'm happy to agree with that point. I want to just briefly touch on the issue raised about the facial versus factual attack on jurisdiction, which is that the court doesn't have to decide this issue, first of all, because it's been forfeited. It wasn't raised until the reply brief on appeal, and it actually contradicts the opening brief where plaintiff multiple times conceded the court may consider extrinsic evidence, and he did rely on that evidence in his briefs in the district court and in his opening brief in this court. But even if it weren't forfeited, it wouldn't make a difference here because plaintiff himself incorporated most of the documents into his amended complaint at JA 69, and he submitted many additional documents and incorporated others into the motion to dismiss opposition at JA 127, which would make those documents fair game for consideration even under Rule 12b-6. And I think if the court were inclined to reach the merits, it's clear that everyone understood this as a factual attack. There was a large amount of extrinsic material submitted in favor of and in opposition to.
Can I ask a final question?
Sure.
I asked your colleague about this. We think about Becerra and Mowry as being cases about the process and how that gets protection even though it's not the ultimate decision. But both of those are individual decisions, right? Becerra and Mowry are specific to an individual. And here, what we're not allowing inquiry into is like the maintenance of a database, which is not specific to Mr. Patel, right? The government's not making a decision about investigating or not, or failing a test or not. Why should we extend Egan to that type of decision as opposed to the specific decision that's made in Becerra or Mowry?
Your Honor is absolutely right. Becerra and Mowry obviously involved decisions at the end. And I think it's partially a factual point that I've tried to make is that we have this odd situation where the DOD simply lacks authority to do anything with the IR right now, but it will certainly investigate it and adjudicate it once it becomes appropriate to do so. And the second point is that obviously Becerra and Mowry recognize the process point, but there's specifically a sentence in Egan that I think really gets at this, which is there's the first sort of quintessential. I see my time's expired. May I finish?
Yes, please.
Thank you. It is not reasonably possible for an outside, non-expert body to review the substance of such a judgment, predictive judgment, and to decide whether the agency should have been able to make the necessary affirmative prediction with confidence. That's the heartland decision-oriented part of it. And then the next sentence says, nor can such a body determine what constitutes an acceptable margin of error in assessing the potential risk. That's Egan at page 529. And that is exactly what we have here, is the claim at its base asks a court to go in and decide whether this IR is actually relevant or actually necessary to a clearance determination. And that's something that the decision makers with the specialized expertise in adjudicating security clearances have to make that call. Thank you, Your Honors. And we ask that the court affirm the district court's judgment.
All right, thank you. Ms. Brown, you have 4 minutes in rebuttal.
May it please the court, I have 3 points on rebuttal. First, I would like to draw attention to Reinbold. Reinbold shows that the Egan bar does not apply to records. It applies to national security clearance investigations. In Reinbold, there are 2 decisions made. The first stating that Egan barred review of a claim that required the court to determine whether an individual's security clearance is wrongly suspended. And the second was a records decision, and the court went ahead and examined that on the merits. Second, the incident report is sitting in JPAS. It is collecting dust in the sense that the Department of Defense has never investigated or adjudicated this information. Yet, for Mr. Patel, this incident...
You don't disagree with the idea that the DOD is barred from doing so under the applicable law? They can't investigate it until it's relevant, right? So they can't investigate it until Mr. Patel either has a job or is some relevance has come to issue, right?
Sure, yes, Your Honor. But the Egan, in our understanding of Egan, it is to bar the review of the executive branch's decision as to a national security matter, a decision or an investigation, neither of which has been made here. Mr. Patel is not second-guessing any decision made by the government here. And moreover...
Why isn't he questioning the decision to maintain this incident report in the JPAS? Right, like that's what it seems like to me he's questioning that decision. That's a decision of the government, right?
Yes, Your Honor, that is correct. I should have been more specific in my language. Mr. Patel is not questioning any predictive judgment regarding an individual. So in the cases of Egan or Mowry or Becerra, these were judgments made by the government as regards...
Why was Becerra a predictive judgment? Becerra just says, we need to investigate. Right? That's not a predictive judgment itself, right? That's just, we need more information, right? You might say, like, the decision to hold on to an IR and a JPAS.
Well, in that instance, the Navy had sufficient reasons to investigate the plaintiff's potential security risk, and that we believe goes to Egan. And here there's been no adjudication, no beginning of an investigation here.
And so in Becerra, you think it turns on the court finding that there were sufficient reasons? It evaluated the reasons that the Navy gave for instituting an investigation? I thought I understood Becerra to say, it doesn't matter what the reasons are, we don't get to second guess that judgment. Right? The decision to institute an investigation, we don't get to second guess as you said, the sufficient reasons or find them insufficient, right? That's just unreviewable.
Yes, Your Honor. And there is no decision because there was a decision to investigate there, so that is where I'm distinguishing this. There is no decision to investigate. I know my colleague speaks of the potential of a future decision, but the fact is that there's no cases cited that show that Egan covers the potential of a future security national security investigation. So without making any determination as to whether the information, well, thank you, Your Honor, for your time today.
All right, thank you. We appreciate the arguments of both Ms. Brown and Mr. Baumhart, and we particularly want to recognize and thank the Georgetown University Law Center Appellate Litigation Program for your court-appointed work on behalf of Mr. Patel. And we'll come down and greet counsel and proceed to our last case.
Did 12B6 motions and 12B1 motion on a conflicted record, factually complex matter, and with substantial disagreement both amongst the defendants, amongst themselves, and also in conflict with the complaint that was before the court. Fundamentally, this case starts on February 9th, 2020, and unfolds a sequence of events that has changed Mr. Wells's life. The story started with Mr. Armstrong, who is a civilian. He is an employee of the Department of Defense. He is not a military member at the time. This is not a military adjacent officer. This was a civilian employee of the DoD. He viewed Mr. Wells from within Arlington Cemetery, from a pretty far remove, Your Honors, and so he viewed Mr. Wells and took a number of minutes to exit Arlington Cemetery, to come around through Fort Myer, to exit Fort Myers Gate, and then park his vehicle behind Mr. Wells's car. Mr. Wells, as observed by Mr. Fuentes, Mr. Wells was not free to leave when Mr. Fuentes later arrived, an Arlington County police officer. And so at that time, Mr. Armstrong detained Mr. Wells and had no basis for it whatsoever.
Just to make sure I understand where the rub is there, I think I do. If Mr. Armstrong had instead pulled up beside Mr. Wells, you agree there would be no claim against Mr. Armstrong?
No, Your Honor. There's two different parts of that as well. I think it does make Mr. Armstrong's case stronger. However, the interaction afterwards between Mr. Armstrong and Mr. Wells, which is, I believe, not recorded, but is a matter of disagreement, Mr. Wells very clearly articulated he believed he was not free to leave, even from the verbal interaction. And so at that point, as soon as Mr. Armstrong approached Mr. Wells's vehicle, Mr. Wells at that point was in a reasonable apprehension that he was not free to leave and therefore detained for the purposes of the Fourth Amendment, Your Honor. Fundamentally, there was no reason for Mr. Armstrong to engage with Mr. Wells. He did not at that time, and I'm stepping forward to respond to Mr. Armstrong's assertion that there was this community caretaker exception. There was no call for medical care. There was no report of anything having to do with a person who may be in medical need or anything along those lines. There was no welfare check and no community caretaker facts.
Your
contemporaneously.
position is, so our sort of fundamental idea here is like, did the officer act in a reasonable manner? We can talk about what buckets it might go in or not, but your suggestion is that it would have been reasonable, given what he saw, to stay in the cemetery and go about his business?
I think that's the only appropriate thing that Mr. Armstrong could have done, Your Honor, yes.
When did this occur? What was the date?
February 9th, 2020, Your Honor. And also there were very few vehicles around. There's no report of misconduct by Mr. Wells. For example, there's no calls to the police by anyone other than Mr. Armstrong. And I think I would say to the
And
court.
Officer
I'm sorry.
Armstrong didn't actually search the vehicle himself, correct? The other officers that were called to the scene because the license plate had expired, they conducted the search of the vehicle, correct?
Mr. Armstrong participated in the search, yes. For approximately 30 minutes or so, his voice can be heard on the audio recording that has been submitted. In that audio recording, you'll hear a male voice ask Mr. Wells, where did you detach from? The male voice then speaks about his own military service, and I would suggest
So
that that's-
participating in the search, by that you mean continue to have communication with Mr. Wells?
The voice, who I believe is Mr. Armstrong, is also heard, I believe, on a phone call calling back to someone else. He's investigating, is the point, and he's working with...
But he's not in the vehicle rummaging around?
I believe he was, Your Honor, yes.
And based on what?
And again, there was no discovery in this case, so it's very difficult for me to answer that question, Your Honor. I think there should be a robust discovery in this case, and in that we would get that set and clear. But in short, Your Honor, from the very get-go, Mr. Armstrong violated the Fourth Amendment. Whether his violations were more egregious by searching the vehicle is a question to be determined.
And you have a number of allegations in this case because, so many events unfolded. What do you think is your strongest argument?
I think the primary issue is this interaction between Armstrong and Mr. Wells. He clearly apprehended him or detained him without reason, and then that set into the sequence of events of the malicious prosecution and the harms to Mr. Wells. I think the second part of it is the Arlington County police officers, I'll refer to them by group, the ACPD officers who appeared on February 9th, jointly worked together to search his vehicle without any justification. The vehicle search.
Well, and of course, they're saying that they were relying on what Armstrong relayed to them, and I think there's case law that says that they can.
I understand, Your Honor. That may fly if there were not this community caretaker exception, and so that they can't have it both ways. Armstrong can't simultaneously have a community caretaker exception to his encounter, and then the only report that he makes that's in paper is suspicious person, and 5 officers come out from
Right, but they were
Arlington
going to
County
have to
Police.
tow the vehicle because it had an expired license. At least that's what the officers said they were going to do.
That is a very, the timeline is very important with this, Your Honor, because you can hear in the audio clip that they're searching the vehicle. Mr. Wells is asking, what are they doing? Why are they doing that? They're searching the vehicle long before there's
Because
anything about towing.
they asked if he had weapons in the vehicle, and he said he did, so they were searching the vehicle for that.
I think the most important issue from the Crow-Marty case and also from Arizona v. Gant, that it is inappropriate for them to take that as a carte blanche, that they can view anything in the vehicle and pull out anything in the vehicle. And also, Your Honor, in Commonwealth versus Hill, Your Honor, in Commonwealth versus Hill, there was a firearm that was, and I'm sorry, this is a Virginia Circuit Court case, so it's not a federal case, but in the court addressed that just because Hill possessed a firearm and there was a firearm in view in the vehicle, it was not appropriate for the officers to then investigate and search and seize, and
What
the
was their
distinction.
stated reason for saying that they were going to need to tow the vehicle?
The stated reason by the defendants is that because the temporary paper tag that was approximately 4 months expired was expired, and
Right.
therefore.
So
could
they
not-
said they were going to need to tow the vehicle, and then for everyone's safety and for protection of whatever might be in the vehicle of value, they gave Mr. Wells the opportunity to, for them to take it over, if he could find a ride or somebody that could come and get him and the firearms, correct?
And that is the pleading from the defendants, Your Honor, and there's it's sort of a choose-your-own-adventure kind of exception to the Fourth Amendment, and it's hard to hit all of these moles. The problem is the vehicle search exception doesn't. They have to do this according to policy. The South Dakota v. Opperman
Does it
case.
have to be a mandatory policy? So I take, maybe this isn't your argument, and so if I'm wrong, help me. But so if it's hypothetical, right? So don't tell me I'm wrong about the facts, right? But if a police department has a policy that says you may tow a car with out-of-date tags, and if you tow the car, you must do an inventory search of it. And that's the policy. And that's the extent of the policy. It's super clear, right, whatever. And an officer shows up and the tags are expired and they say, all right, I'm going to tow the car, and they do an inventory search. Is that permissible?
Your Honor, I will address your question. I was responding to the vehicle
No,
search
I'm
exception.
totally
So-
changing it.
I understand.
I'm asking a different
Yes.
question. Yep,
Yeah,
I'm totally asking a different question. That's what we get to do.
Yes, Your Honor. So there is a permissive policy, yes, absolutely. And so the argument is not so much that they could not tow the vehicle. That's not the argument. That's not the Fourth Amendment violation. The searches happened long before they made the determination that Mr. Wells could not find a person to come to him, and you can hear that in the timeline in the audio recording. That Mr. Wells was still speaking to friends while two of the officers from a remove are discussing Mr. Wells, and they have choice words to say about him, but they don't believe him. They don't believe. They said that they're going to take everything.
And you
So they've
think,
already made their
you
mind
think
up.
the Fourth Amendment requires, so they have a policy, they can do an inventory search, but if they offer him the chance to have somebody come pick him up, that somehow now imposes a Fourth Amendment obligation to not conduct the inventory search?
The problem is that they did not do a vehicle inventory search appropriately in violation of the Fourth Amendment. And that's the main thrust of the argument, Your Honor.
In other words, that it needed to be done, what? Like, what did they not do? On the inventory search, I get, as Judge Thacker rightly says, like, you've raised 17 issues, right? But on the inventory search itself, where they found the plate, let's just focus on that. Help me understand, what is your argument for why they were not permitted to do that, given that he had expired tags?
The Fourth Amendment injury, from South Dakota to Opperman, there's three valid purposes. They need to protect the property owner's property within the vehicle, protect against claims of theft or damage, or to protect the police from things like bombs, et cetera.
But
So the
that's
issue.
why you have a policy, right? It's not a requirement that those reasons be invoked every time the policy is used. That's why you can have an inventory search policy. But the officers don't need to write out the reasons why they're doing it. They're just following the policy. They get to follow the policy.
If they had followed the policy, they would have a better argument, but I still think that there's Fourth Amendment violations replete throughout this factual pattern, Your Honor. And part of the primary issue is they did not remove all of his personal property. Notably, they left, and you can hear it in the recording, and it's kind of complicated to explain it, but they even tell Mr. Wells, make sure you have your laptop. He took his laptop with him, so left it in the vehicle. So there was very expensive property that was left in the vehicle, and also the policy requires an inventory and for that to be given to Mr. Wells. It was not given to Mr. Wells, and he did not sign an inventory of what was in the vehicle. So there's numerous policy violations, even if it is permissible. The higher level issue is
And
that
your argument is that if, except hypothetically, that they were required to get his signature on an inventory, that technical violation is itself a Fourth Amendment violation? And I'm just trying to understand how we get to where you're going. That's the argument. That if they don't take everything out of the car, and they don't get his signature, that is a Fourth Amendment violation.
It's worse than that. It demonstrates that they're only using very important exceptions to the Fourth Amendment as a pretext to rummage through his belongings. It is evidence of the further Fourth Amendment violation. It's a gross violation of the Fourth Amendment. And all searches are unreasonable, necessarily unreasonable.
Have you read a case called Wren before?
R-E-N? W-R-E-N. I have reviewed that. I don't recall it offhand, Your Honor.
Okay, so it says we don't really care about pretext, right? If they've got a basis for doing it under the Fourth Amendment, we don't ask about their subjective, intentions, right?
I understand.
You can say whether that's right or wrong, but it sort of binds us. And so why would I, even if you were right, even if it was evidence that they had all these really terrible motives, why does that matter to me? Because those are subjective ideas, even if you could prove them. Mm-hmm. And I have to ask under Wren the objective question of whether they had a valid basis to search the car.
Well, and that's I think the main thrust of this is that all warrantless, non-consensual searches are unreasonable, and therefore qualified immunity does not attach unless they have one of these exceptions. And they've gone through the community caretaker to justify the initial review, the vehicle search exception. These are all, they don't apply. They didn't follow the policy, and therefore they didn't actually use the vehicle search exception. And you can hear it when the police officers are speaking to each other.
Exception? Is that the inventory exception, or are you talking about a different exception?
There are multiple exceptions. Again, it's sort of a game of whack-a-mole of what the defendants are arguing. But
I'm not sure that there is a game of whack-a-mole. I'm not sure it's whether the defendants' arguments or not. But
the primary issue is just if they don't abide by they're initially unreasonable. The search is unreasonable. They could have viewed the firearms and made sure that Mr. Wells didn't touch them, which they did. He was handcuffed sitting on a curb. So that their safety is ensured. They don't have the authority to search the rest of the vehicle. They did not at that time know that they were going, and this is very early on, the first 20 minutes of the audio clip. They did not know at that time that they would have to tow the vehicle. So that's the issue, is that the vehicle was not in police custody. They have to go, and that's the South Dakota v. Opperman case, that they have to go through these policies appropriately, Your Honor. Otherwise, they're just given carte blanche to violate the Fourth Amendment. Search any vehicle that they come across. It's just inappropriate, Your Honor. And the second main issue here is that they argue, and the district court agrees, that there was consent, and there's no consent in the audio clip. Mr. Wells merely gave up, and that cannot be consent to give up one's Fourth Amendment rights. They read him his Miranda.
Didn't they know, right? They knew, Officer Armstrong noticed right away that the temporary license plate was expired. That's why he called the other officers. And so that's what required the vehicle to be towed. So right at the inception, they knew the license plate was expired. That's why they were there. So it was going to be towed, which triggers the inventory search.
I disagree that it triggers the inventory search exception if they don't follow the policy.
Well, that's their argument.
Mm-hmm. I understand. And so the timeline of that is very important.
If they don't follow what policy? Because they didn't give him the inventory search return, correct?
They didn't take everything. They didn't give him the inventory, and he did not consent is an important point as well, Your Honor. The timing of, I'm sorry?
You go ahead.
Right. The timing of when they knew that they had to tow the vehicle is very important because they discussed with him, and Mr. Wells was on the phone. You can hear it in the audio clip. He's on the phone attempting to find somebody. And so the officers said that they were not going to tow the vehicle if he could find somebody to come.
Right, if he could find somebody. But if not, they knew they were going to tow the vehicle. And you have some time on rebuttal.
Yes, Your Honor.
Thank you. You have 3 minutes on rebuttal, so we'll hear from you again then. All right. Next, counsel. Yeah, I think that, are you Mr. Few? Yeah. I have you as going next.
You have a mistake going for it, but I'm happy to go first if that's perfectly.
You go first, and you have 12 minutes? Yes. Okay, go ahead, Ms. O'Brien, and can you change it to 12 minutes, please? Thank you. All right. Now we're back on track. Go ahead.
Good morning, Your Honors. My name is Blair O'Brien. I'm here today on behalf of the Appellees Fuentes, Wanick, Lugase, Solis, Klein, and Vanek, and may it please the Court. The District Court did not err when it concluded that the allegations in the second amended complaint, as clarified by the exhibits that were fairly incorporated into that complaint, into which the appellant did not object in the trial court, did not state a claim against my clients. I have to disagree with my colleague that the district court engaged in fact-finding and resolved the merits of factual issues as part of entering its opinion in the case. On the contrary, the district court evaluated recorded statements, the content of which is not in dispute, and then made legal conclusions as to whether these officers' actions were objectively reasonable in light of those undisputed statements, those undisputed facts. The district court did not err in doing so, and it correctly concluded that my clients acted reasonably. There are two parts to this case, really. They're almost two separate cases. The first being...
There's a lot of parts to this case.
I have to agree with Your Honor there, yes. But if we're looking at two separate events, I suppose, the February 9th stop is one which the court just heard a substantial amount of argument about, and then the second is the investigation subsequent to that led to the charge. I'll address the February 9th stop first, but I'm also happy to entertain any questions. As the court is aware, Appellee Armstrong initially conducted the stop. By the time any of my clients arrived on scene, the stop was well underway. So in light of that, they were relying on Officer Armstrong's conclusions as to whether or not a stop was appropriate in responding to the call to assist that their agency received. The appellant is asking the court to adopt a new rule requiring assisting officers, later responding officers, to engage in their own fact-finding mission upon arriving at a scene to make sure that everything is above board.
He's also saying that they didn't follow the policy for impounding the vehicle. What's your response to that?
Your Honor, I think the record as it stands right now is not clear. I have my thoughts about where it will stand after discovery if that happens. But the bottom line is the record is very clear that they believed that they were conducting an inventory search.
If the record is not clear, should discovery happen?
I don't think it's necessary at all, Your Honor, because the issue here...
So where can we find the policy in the record?
The policy, there are no allegations actually about the policy and whether or not policy was followed, what the policy is and how it was not followed in the complaint.
Didn't somebody testify at some point as to what the policy was, one of the officers that they...
There was testimony at the preliminary hearing in General District Court, Your Honor, yes. And what the policy was if a vehicle could not be driven away from the scene, which this vehicle could not, it had to be towed. And if it's going to be towed...
And it could not because it was not legal, because it had an expired tag? Is that it?
Correct, yes, Your Honor. So the registration was, I think it was actually charged under a fictitious registration statute under the Virginia Traffic Code rather than just expired. So there's, it wasn't merely an expired tag, but nonetheless it was a faulty tag that was on this car and it could never have been driven away. It also couldn't be legally parked in the city, in the county of Arlington. So they couldn't just leave it there either. They had to move it. It couldn't stay, it had to go.
Can you answer the question? You say it had to be towed. There's some testimony from, I believe it's Fuentes, maybe it's somebody else, that says on occasion when it was legally parked, he would allow it to stay there. He didn't tow it every time. Are you familiar with that testimony?
Yes, Your Honor.
Okay. Tell me why that, does that matter or doesn't matter? You made the statement that it had to be towed. That suggested maybe that there was a discretionary policy. And does it matter if it's merely discretionary as opposed to mandatory?
I don't believe it does matter, as the law allows officers to use their discretion in just dealing with vehicles and what is in the community best interest, what amounts to public safety, and what is required to ensure that private property is protected. I think it's unclear from Officer Fuentes' testimony whether or not he was going to leave a vehicle on public property versus, say, if it's in a Walmart parking lot or something like that.
And why? You also mentioned, I just want to make sure I understand, that that because it lacked appropriate registration, it could not be parked in a public spot? Where do I find that? How do I know that?
That's in the Arlington County Code, and the specific section is 14.2-2A2. And so that specifies that if it is not a street legal vehicle, if it does not comply with DMV regulations, then it cannot be driven on the streets and it cannot be parked in public spaces. And so the allegation in the complaint in paragraph 27 of the Second Amendment complaint is that this was a public parking lot. So in that regard, the car could not be left there. So there are perhaps other circumstances when Officer Fuentes may have used his discretion in a different way, or more likely would have been on some kind of private property and would have left a vehicle there rather than tow it.
And there's a factual question, and then I'll let you go back to your argument. Based on the record we have, I thought the officers had suggested to Mr. Wells that he could have somebody come pick him up and they could take whatever items he wanted to take with him, not that someone could come pick up his car.
That is also my understanding of the discussion. And I'm looking at specifically considering the recording that has been submitted. That was the offer that was on the table. In fact, they told him that they preferred for him to have someone come pick him up so he could take his valuables with him.
The conversation starts at 4:48 p.m. where they say, we got to tow your car, but you can get somebody to come pick up your stuff.
Yes, Your Honor.
Okay.
Yes, so I don't believe that there was ever a discussion that another person could come and drive the car. Mr. Wells also did not have a license on him at that point, so he could not have driven any car. But that specific car could not leave under its own operation, given the status of its registration.
So from your perspective, at least by that point in time, they had to do an inventory search of the car.
Yes, and not only that they had to do it, but they absolutely reasonably believed that that is what they were doing. They informed Mr. Wells, I believe the timestamp is 4:37, that that's what they were doing, that they had to tow the car, that they were starting the search. So that is what they were doing throughout the process of allowing Mr. Wells time to try to contact a friend or someone else to come and take him from the scene, is that they were conducting that search. So it's not the case that they eventually decided to tow the car because he couldn't find a ride, that they were pursuing their policy all along while they were trying to find a ride for him.
Is there, in your view, is there any Fourth Amendment requirement that they wait until they get to the impound lot to do the inventory search? Is there a timing requirement under the Fourth Amendment that they can't do the search until a certain point in time?
I don't believe there is a timing requirement. I think I've encountered different practices, Your Honor, for what's appropriate. If the car is locked and they've got chain of custody effectively on it, you could technically wait to get it to the impound and do it there, come back and do a full criminal search later if it's evidence of a crime, for example. But I think if their policy dictated that they do it on the scene, then they appropriately followed that policy. So I don't think there's a Fourth Amendment implication there either way. Your Honor, I do briefly want to touch on the Second Amendment question that has been raised. The district court did not err in listening to the video recording that we've been discussing and concluding that the officers were objectively reasonable in believing that the appellant was consenting to the placement of his firearms in safekeeping. The officers were clear, as I mentioned earlier, that the appellant, their preference was actually that the appellant retain possession of his firearms and leave with them, but they asked him to do it in someone else's vehicle so that he was not simply openly carrying a loaded assault rifle down Arlington County streets. They offered safekeeping as an alternative to that, and ultimately the appellant...
Is that a crime, though, to open carry in Virginia?
It is not a crime to open carry in Virginia, Your Honor, but I suppose I would say that that's actually not the standard for a constitutional question. There are states where it is a crime to open carry a firearm of any variety, and particularly an assault weapon. And the Constitution is the same in California as it is in Virginia. So what the Commonwealth of Virginia criminalizes is not the standard for what would be a constitutional Second Amendment type claim.
Your argument is, had he demanded to walk off with the guns and the officers had refused him, that might have raised a Second Amendment problem. But the officers were entitled to say, hey, don't you think it's a good idea for us to hold on to him? And if he agrees to that, that certainly doesn't violate his Second Amendment rights.
Your Honor, I might push back a bit. I'm not sure that I would agree it would raise a Second Amendment problem. There might be other
I said
amendments.
might, that's what I was saying. But to distinguish from what we have here, which is fundamentally just a consent question, we would have to ask the question of whether that actually violates the Second Amendment.
Correct, Your Honor. And so our first position is that he consented, so that's not what happened. But if the officers had affirmatively taken the guns and said, no, you can't leave with these, I still don't think that that's a Second Amendment question, Your Honor, because I don't think it's clearly established under any of this court's precedent or the Supreme Court's precedent that there is a clearly established right to walk down the street with an assault weapon anywhere in the country at the moment. Appellant is relying on Bruin, which was, of course, decided 2 years after the facts of this case. So that would not contribute to the clearly established analysis. I do think it could implicate other amendments, like a takings question, whether or not the government can take a whole property. It could be potentially a Fourth Amendment question of a seizure. But I don't believe that they've shown precedent that would implicate the Second Amendment specifically related to the possession of the firearms. In my brief minute I have left, I do want to separately address Detective Wanek very quickly. There are allegations in the complaint related to alleged false statements that Detective Wanek may have made to a magistrate, to the Commonwealth's attorney, or to a grand jury. Our first point is the same as to the original officers responding to the scene, that he was reasonably relying on information that he reasonably sought from a military police officer about the origin of the rifle plate that's at the heart of the prosecution. So his actions there were reasonable. I'd also point to the preliminary hearing in this case, which would function as an intervening cause for the prosecution that occurred in this case. Appellant points to the magistrate and the Commonwealth and the grand jury, but ignores the preliminary hearing at which all of these alleged false statements were sussed out and were subject to cross-examination, and a probable cause determination was found. So I believe that concludes my time. I appreciate it. Thank you.
Thank you very much. All right. Now, Mr. Pugh.
Your Honors, and may it please the Court, Assistant United States Attorney Yuri Fuchs for Federal Defendants Officer Armstrong, Detective Shepard, and the United States of America. Your Honors, the Court should affirm the District Court's dismissal of the secondary claims against federal defendants. Plaintiff's allegations against the 3 federal defendants are a narrower set of his main claims relating to the inventory search of his vehicle on February 9th, 2020, and subsequent events thereafter. Regardless, the District Court correctly dismissed these claims for failing to meet the threshold requirements of Federal Rules of Civil Procedure 12b1 and 12b6 on plaintiff's own pleadings and plaintiff's own incorporated materials.
Well, let me ask you about that, because the District Court heavily relies on the, as to your client, the exhibits attached to the complaint by Armstrong. And in looking at the District Court order, the District Court gives credit, or seems to give credit to those statements, which may be in conflict with Goins, because they're self-serving statements, and does not consider what is pled in the complaint by Mr. Wells.
I respectfully disagree, Your Honor. The District Court does give credence to plaintiff's allegations that he was subject to a seizure, and looking at the incorporated materials says there is a seizure. As with respect to what the District Court concluded, there is one lone paragraph pled in the second amended complaint about Officer Armstrong's testimony at that motion to suppress hearing. Plaintiff excerpts Officer Armstrong's discussion with plaintiff after he comes upon him. What he does not excerpt is a part of that same motion to suppress hearing where Officer Armstrong explains why he came to plaintiff in the first place. There is nothing else in the second amended complaint that counters that reason. There is nothing in the second amended complaint that says Officer Armstrong's reasons were a pretext. There is nothing that says that Officer Armstrong shouldn't have believed that there wasn't a medical emergency, as plaintiff argues now. There is nothing related to any kind of racial component that plaintiff raises for the first time on appeal. There is no conflict on the record that the District Court resolves, and we'd also submit, Your Honor, that there is a prefatory issue of whether a Bivens claim can rise against Officer Armstrong to begin with.
Well, I mean, and I was trying to, in reading the lower court's opinion as to the Bivens, as to Armstrong, it almost seems as if they're saying that there is maybe a claim on Bivens, on Armstrong?
I think the district court's opinion is best read as assuming arguendo. I'm going to assume arguendo that there is, even though this court's decision, because there's qualified immunity. I think also to touch on qualified immunity, Your Honor, even if supposedly the district court, there was a constitutional violation, there's no clearly established violation of law. Plaintiff has yet to not point to one in lower court, and he does not point to one on appeal. And that is
the Hicks, I guess it's Hicks 2, and of course that came out after briefing.
Sure. So Hicks 2 deals with the Hicks 2 v. Ferreira deals with a very narrow question of whether a Bivens claim can lie against the particular U.S. Park police officers. It involved very different facts and circumstances. It involves an issue where U.S. Park police twice stop an individual despite him being authorized to be there. This is a very narrow instance of Officer Armstrong acting subject to a completely different statutory and regulatory mandate, as this court has held in Tuncos, is actually dispositive of the new context inquiry under Bivens and implementing a welfare check. That is noticeably different from Hicks, I would submit, in three ways, Your Honor. One, Hicks never touches on claims against Department of Defense personnel, the kind that this court and the Supreme Court have repeatedly held represent an extension of Bivens. And that's regardless of whether it's against military personnel, that's regardless of whether plaintiffs are or are not military personnel, that's subject to all DOD personnel. And that's the case in this court's decision in Keoka v. Rumsfeld, LeBron v. Rumsfeld, Doe v. Marin, and that all stems back from the Supreme Court's decision in Chappell and Stanley. Hicks is also different because, as this court noted in Tuncos and several other decisions, the statutory regulatory mandate on which an officer operates is material for determining whether there is a new context. The U.S. Park Police, as this court noted in Hicks 2, are traditional line-level enforcement officers. In fact, the U.S. Park Police, Your Honor, I think is one of the, if not, I think it is the oldest federal law enforcement agency and has sweeping powers over certain jurisdictions. By contrast, Officer Armstrong here is operating under a confined Army mandate. He is not freewheeling, going around Arlington County arresting people. He is at Arlington National Cemetery to protect Arlington National Cemetery because that is part of his specific mandate under the auspices of the United States Army. So to continue, Your Honors, the district court here correctly concluded on the pleadings before it, as I've noted before, that sorry, to back up. The district court correctly noted the plaintiff could not state a Bivens claim against Officer Armstrong or Detective Shepard in their individual capacities, as Bivens actions were not cognizable against them, or they were otherwise shielded by qualified immunity. Meanwhile, as to the United States of America, the district court correctly held that the tort claims, individual tort claims brought against the federal officers had to be brought against the United States under the auspices of the Federal Tort Claims Act, and that those claims were subject to dismissal under the discretionary function exception. Plaintiff's briefing on appeal and his argument here is devoid of meaningful response to a lot of these key bases. He abandons any kind of Bivens claim now against Detective Shepard. As to the Bivens claim against Officer Armstrong, he has no meaningful rebuttal to the existence of special factors counseling hesitation against the extension of a Bivens remedy. As to the grant of qualified immunity to Officer Armstrong, as I've noted before, Your Honor, he does not identify any clearly established violation of law so as to preclude the application of qualified immunity. As to the Federal Tort Claims Act, even though plaintiff below moved to strike the notice of substitution of the United States of America, he concedes here that he presented no evidence, and this court's opinion in Gutierrez is on all fours, requiring that even on the pleadings, an individual must come forward with evidence to rebut the scope certification of a U.S. attorney once the United States is substituted for claims against individual officer defendants. And plaintiff does not show any prescribed course of conduct or policy that Officer Armstrong or Detective Shepard violated in their alleged conduct. And he has no rebuttal to this court's decision in Souter, as well as a Court of Appeals decision from the Ninth Circuit and several other Court of Appeals decisions that have repeatedly noted that law enforcement investigative decisions of the kind that he challenges are axiomatically shielded from liability under the discretionary function exception. Your Honors, I have about 45 seconds left. I'm happy to answer any further questions or just rest on my papers. Thank you, Your Honors.
Thank you. All right, and finally, Mr. Christ, we're happy to hear from you again for 3 minutes.
Thank you, Your Honors. I'll try to work backwards from Mr. Fuchs' remarks. The discretionary function test requires do care. This is not that kind of case. The Congress did not pass that to protect these kinds of usurpation. So the main issue with the Bivens, whether this is a circumstance counseling hesitation for an extension of Bivens, it is not, and we don't have to get there, because this is exactly the same as Bivens itself, and Hicks, Your Honor noted that Hicks came out afterward. However, Bivens itself is line-level officers investigating. That's Mr. Armstrong.
What's your response to the DOD point?
That he is an employee of the Department of Defense. He's a civilian employee of the Department of Defense. So there is no...
Any of our cases suggested that it turns on whether, what position they are with the Department of Defense? I mean, there are all of these cases that say, whatever we want to say about lots of things, like the Department of Defense is like different.
Mr. Fuchs, he referenced a lot of cases that I tried to tackle in the reply as much as possible. Far too much for a minute 50. But the primary theme of all of those cases, for an example, where they're talking about Stanley, where I think he's dosed with LSD, and that was while he was in the military. There's the Navy civilian, I believe, like social workers. That is sort of the closest that we get to connection to this, a civilian employee of the DOD. In that circumstance, the court doesn't turn on whether they were, well, first off, they were not line-level police officers investigating a crime, as Mr. Armstrong was. So I don't think that it applies whatsoever. The hesitation that the court had was because they were talking about intervening with very high-level policy and not, like I said, a line-level officer like Mr. Armstrong. There's night and day differences, Your Honor. And I would answer the court's question, no, I don't believe that there are specific circumstances like this of a DOD civilian officer investigating a crime and violating the Fourth Amendment, as Mr. Armstrong did. Your Honors, there is a conflict in the testimony. Mr. Armstrong's testimony conflicted with Mr. Fuentes' testimony in as to how long Armstrong stayed on scene. And Mr. Armstrong and Fuentes' testimonies also conflict with Mr. Armstrong's pleadings filed in this court.
And he made a deal of that. Why does that matter? I mean, I get maybe there's a difference, right? But what's material about it?
I think it's false exculpatory testimony, well, false exculpatory pleading indicating a guilty conscience that he knew he did something wrong. And that's why he manufactured the caretaker exception. I think that it fundamentally demonstrates...
Because they disagree about allegedly disagree, I'm not sure there's a disagreement, but allegedly disagree about how long he was there?
Mr. Armstrong stated that this was a brief 1-minute encounter, that he removed himself. That's not true. Mr. Fuentes said that when he arrived minutes later, that he saw that Armstrong's vehicle was still behind Mr. Wells's vehicle in the parking lot. So that distinction by itself, I think that any false statement by a witness or by a defendant is very important, but I think it demonstrates that Mr. Armstrong was aware that he had no community caretaker exception. That was an after-the-fact generated argument. There was very clear indication that the district court understood and agreed that Mr. Armstrong violated, I believe I'm over my time. If I may just briefly conclude, Your Honor.
Briefly, please.
Okay. Your Honors, Mr. Wells did not consent to the searches and seizures on February 9th, and the defendants did not operate according to policy. There was no valid basis for these Fourth Amendment violations on February 9th and the subsequent actions against Mr. Wells. The district court erred in finding qualified immunity as an affirmative defense on this record. And the district court's June 2nd, 2023 order should be reversed, in this case remanded to permit Mr. Wells to finally seek justice. Thank you, Your Honors.
All right, thank you. We will come down and greet counsel and ask the clerk to adjourn court until tomorrow morning.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court. Yeah, is that